Good afternoon, everyone. Welcome to the Appellate Division First Department. There are over 6 hours of requested time for argument. Obviously, we cannot do 6 hours of, 6 hours of argument time. So again, I'm going to ask that you request only the time that you actually need in order to get out the salient points of your argument. Please keep in mind we have read your briefs. We are fully familiar with your arguments. The light is for you, not for us. Obviously, if we have additional questions to pose to you, we will certainly do so. People v. Delaney.
Good afternoon, Your Honors. People request 4 and 1.
414. Perone v. Suarez Water.
Good morning, Your Honors. The appellant request 4 and 1.
Good afternoon, Your Honor. William Miller, the respondents request 4 and 1.
You have a cross appeal?
No, I'm sorry. 4 minutes.
414. Matter of Saki. That matter is submitted. Romero versus the City of New York.
Appellant request 4 and 1, please.
414. Sullivan v. New York State Division of Human Rights.
Petitioner requests 4 minutes and 1 minute.
Hi.
Yes, respondent requests
414. See, this seems to be the going thing is 4. That's good. That's good. Con v. Garg.
Good afternoon, Your Honors. The appellate request 7 and 2.
See, and you had to break the streak.
Yes, Your Honor, I did.
Respondent request 6.
Yeah. 5-2 and 525. Mulberg v. Phoenix Cayman Limited.
Good afternoon, Your Honors. Appellant request item 2.
Respondent request, or I'll go back to the prior.
You go back, thank you. 524. People v. Shamel Rodriguez.
Appellant request 6 and 2, Your Honor.
625. Ansbro v. Negro.
Appellant's request 8 and 2, Your Honor.
Respondents request 5, Your Honor.
625. Fuentes v. 158 Management.
Good afternoon, Your Honor. Appellants request 4 and 1. Good afternoon. Respondent request 4.
Who do you represent?
Respondent
Fuentes?
Fuentes.
And you're requesting?
4 minutes, please.
Who's? City? Thank you. 4143. Stern Clark, versus Davis.
10 and 5.
Respondent 3.
623. Castro v. Brito.
The appellant's 5 minutes due for rebuttal.
I'm sorry, respondent? 525. Kander v. New York City Department of Housing Preservation. I have an appellant. Just made it, huh?
3.
You are?
Respondent 18 hours.
And?
Respondent HPD request 4, Your Honor.
5234. Edwards v. Arrowcross Capital. 624. People v. Antoy Thompson. That matter is submitted. Arthur v. ACS. You are the petitioner? Yes. Who's next? It's okay, don't, it's okay. Who are you?
I'm Allison Office.
Right, so you have individuals behind you. Who are the respondents?
Respondents request 4, Your Honor.
City is 4, and?
For the state, 2, Your Honor.
Okay, so that's 6, 4, and 2. First case for argument is People v. Truman Delaney. Yes, you may proceed.
Good afternoon, Your Honors. May it please the court. Nkechi Irandu for Appellant Truman Delaney. We are asking the court to reduce Mr. Delaney's 18-year sentence in the interest of justice in light of his serious and chronic mental illness that
Was his serious mental illness, was this known to the court at the time of the plea?
Yes, the court was aware. However,
And in fact, did not the people state that the reason why they were offering the 18 years as opposed to the 25 on the man one was because of his mental illness and the history of his mental illness?
yes, but this court has the authority to reduce his sentence and has done so in the past.
And why would we do so now, again, given the facts of the case?
I would direct the court to look to the days prior to the incident to really, because it elucidates Mr. Delaney's
This is
mental.
before he locked the two older individuals in the room, before he killed the male individual, before he asked the male individual for his debit card as well as the PIN so that he could go to the bank in order to withdraw the funds.
So, again, I want to really underscore the severity of Mr. Delaney's mental illness because he did call EMS leading up to the incident because he was genuinely
What were
fearful
his diagnoses? What were they? Bipolar disorder,
and paranoid schizophrenia. And
PTSD,
yes,
and ADHD.
yes.
And was he taking medication for this?
So he was given medication when he was admitted to the psychiatric unit. And he
No,
was-
prior to the incident, when he came from Mississippi to New York, was he taking medication then?
No, I don't believe he was taking any medication because he hadn't been in a place to receive treatment.
Was he not a veteran?
Yes, he was. a
My
veteran.
understanding is that the Veterans Hospital, they do dispense medication. They are able to make a diagnosis and to dispense medication.
But prior to when Mr. Delaney was in Mississippi, he was houseless. He didn't. He was.
I was wondering, I always find it interesting. People are undomiciled, but yet they still have access to Facebook because that's how he met the two individuals here in New York, right?
Yes, he must have had access to Facebook, but again, Mr. Delaney was houseless, and people do.
He was well, I thought he was living in some type of
Storage.
what was it?
Storage.
Yeah, storage unit or something like that?
Yeah.
But this is all kind of academic in terms of the waiver. Why? Because we do have a valid waiver of his right to appeal, do we not?
Yeah, and so the appeal waiver was invalid for two reasons. Number one, the court said that Mr. Delaney would only have the right to appeal if he went to trial.
Well, that's not correct. I saw that in your papers. That's not what he said. That's not what the court said. She gave that as an example. She said, as an example, if you went to trial, there would be certain rights that you would be giving up. But she did not state. The judge did not state that those rights are only there if you go to trial,
But then
not if you plead guilty.
But then the court continued and said, hands off. By signing the appeal waiver, Mr. Delaney was saying, hands off. You don't have to decide anything, which isn't true. While it's true that the court then, later listed the surviving issues, Mr. Delaney kept sort of receiving the message, and that message kept being reinforced by the court that he had no right
There was
to appeal.
a written right to appeal as well. Is that correct?
There was a written right to appeal, but this court has found that a written right to appeal does not absolve the court from providing a clear.
No, the court said to the defendant, after explaining the waiver, asked the defendant, do you understand everything that I've said? The defendant said, yes, ma'am.
Yeah, but I think someone in Mr. Delaney's shoes who is undergoing his first appeal, his first plea, his first New York.
Well, there was a plea before in Mississippi, right? I don't know what the allocution is like in Mississippi Supreme Court, but he did plead guilty, I believe, to a burglary where he received 10 years incarceration.
Yes, that's true, 30 years ago, but I
Right.
will reserve the rest of my time for rebuttal.
Thank you. You do have time on rebuttal. Yeah, whenever you're ready.
Good afternoon, Your Honors. May it please the court, ADA Ethan Solomon for the people.
Counsel, can you address the issue of the waiver? Did the court, in this case, during the allocution, did it explain to the defendant that the right to appeal was separate, et cetera, et cetera?
Yes, Your Honor, it did. The court first went through the rights that defendant would retain at trial if he didn't plead guilty and asked defendant if he understood. Defendant said that he did. The court then turned to the rights relevant to the appeal. Further, the court asked or instructed defendant to consult with his attorney off the record in that proceeding before the defendant signed the written appeal waiver. to the extent that there was any ambiguity in the court's allocution, the written appeal waiver would serve to cure that ambiguity because the appeal waiver is very specific about which rights survive and which ones do not.
Well, the court does state, for example, had you gone to trial in this case and been convicted, why was that not misleading to the defendant?
Well, because I think, as you noted, Your Honor, the court was using that only as an example, and defendant did have ample time to clarify with his attorney exactly what rights were surviving and what rights were not.
And the court also stated, by signing the waiver, you're telling the higher court, hands off. You don't have to decide anything. I'm going to accept what the lower court, I'm going to accept the lower court's decision. Was that not, your friend states that that was confusing to the defendant?
To the extent that it was ambiguous, Your Honor, the written waiver was very clear about exactly which appellate rights survived and which ones did not. And as this court has noted, a sufficiently strong written waiver can cure certain ambiguities in the allocution. Even if this court chooses to reach the issue of the sentence, this court should decline to...
Had defendant gone to trial and had been convicted, what was he facing at that point?
On the top count, Your Honor, if murder 2 is what he was charged with, he was 15 to life.
Did the people ever prepare a competing psychiatric report? I know Dr. Jason Hirschberger was supposed to. Did that ever happen?
I am not aware, Your Honor. If this court chooses to reach the sentencing issue, it should decline to reduce defendant's sentence further. As Your Honors noted, defendant was offered this plea by the people specifically because of his mental history. The sentencing court was well aware of his mental history, and to reduce his sentence further would effectively let defendants double dip on that mitigating factor. It would also encourage defendants to treat this court as a sort of end run around the plea bargaining process. And for those reasons, unless there are further questions, we'll ask this court to affirm.
Thank you.
So 18 years for a person like Mr. Delaney with significant and severe mental illness is not going to be helpful to him. He needs treatment, not incarceration. And this court aptly noted in People v. Sparks that default incarceration for crimes caused by mental illness is antithetical to the interest.
And
No one died in People v. Yusuf Sparks, correct?
Of course, but I think the focus.
No one was tortured in Sparks either.
But the focus of that statement truly is on the person who has committed the crime, right? So it's important to look to the factors and the mitigating circumstances that are present here.
And so was that not taken into consideration by both the trial court as by by Supreme Court as well as by the prosecution by offering a lesser sentence?
Yes, it was. But again, this court can choose to reduce sentences in situations like this, where Mr. Delaney really did try to seek help.
When did he try to seek help?
He called the police 6 days prior to the incident, and he said that he was genuinely fearful for his life. And he was then voluntarily admitted to a psychiatric unit and provided with medication.
And then he killed someone and kidnapped and held the two individuals captive.
But he was clearly still in an acutely psychotic state.
So he was in a psychotic state, but he knew enough to get the debit card, to get the PIN number in order to go to the bank in order to secure funds.
All we can really look to are the psychiatric notes that were included in the medical examiners.
Did the people ever contest the conclusions drawn by your expert?
Not that I'm aware of, they didn't, but again.
And then they offered the 18 years.
With the minimum being 5. So all we are saying is that we ask the court to disregard the invalid appeal waiver here and reduce Mr. Delaney's sentence.
Thank you. Thank you both. Perron v. Suez Water.
May it please the court, my name is Amanda Walsh for the appellants Suez Water, Westchester Inc. and J. Fletcher Creamer and Sons. This motion is a motion to compel the third-party defendants, Danielle and Michael Milano, to produce various documents, including the full name and the full name and the realty company which assisted in the purchase of the subject property at 64 Hillside, the name of the attorney.
If you could just keep your voice up just a little bit or move the mic closer to you. So is this material necessary in the prosecution or defense of the action?
Yes, Your Honor. These documents would go directly to the issue of liability with the subject property.
In fact, the pre-inspection reports would be relevant because the time frame isn't that far off, right? The property was purchased July 1st, the accident happened at the end of July?
So the accident actually happened December 1st, 2017. However, Your Honors is correct when they note that the property purchased was done in July 2017, and the work that my clients performed finished on July 31st, 2017, so only a few weeks. These pre-purchase inspections and photographs would actually predate the purchase of the home itself. And by looking at these photographs, it would either be able to affirm that this defect predated the incident and would thereafter put
So I understand about the pre-inspection reports and maybe even the mortgage, where they have their mortgage, because that relates to that, obviously. But the name of the attorneys and the realtor?
So at her deposition, Ms. Milano stated that she could not recall the full name of the realtor. So that would go to the name of the realty company, which served the listing to Ms. Milano, which included photographs of the property, which would, of course, or most likely show the land abutting where the defect did occur, where Mr. Perrone is alleged to have tripped.
Right. The disclosure you're seeking doesn't have to be admissible, of course. That's a truism, right? It just has to lead to admissible evidence.
I'm sorry, could you repeat that?
I'm just stating the obvious, which is disclosure only needs to lead to admissible evidence. It doesn't have to be admissible itself.
Yes, Your Honors. It would only lead to, and that would allow us to definitively state whether my client either made or exacerbated this defect, which would, of course, if this depression predated our work, this would be a huge shift in liability, which would aid in the defense of this matter. And it would actually do a full shift because according to the city charter of New Rochelle, the landowners are the ones who are responsible for the maintenance and repair of any sidewalks or curbs abutting their property. And unfortunately, the Milanos were unable to testify as to if they themselves had the documents. We specifically requested—
She couldn't recall the name of the bank that she used to have the mortgage with either, correct?
Correct. She could not recall the realty agency, the mortgage, the bank that held the mortgage. She could not recall the name of the attorney or the firm which assisted in the purchase of this property.
And even though the closing had happened about 6 months prior to the incident, correct?
The closing did happen about 6 months prior to the incident. It actually happened just prior to my client's work in the subject at the subject property and in the area. So this would directly show the extent of this depression, whether my clients who testified that they may have dug under and that they would not restore,
Thank you.
Good afternoon. William Elder for the respondents.
Counsel, understanding that material and relevant is interpreted liberally, why isn't the pre-inspection report relevant to this particular action where the pre-inspection report, or the property was purchased in July and then the work done by the defendants happened less than maybe 30 days later?
Right. I believe that was covered with the Jackson affidavits, because my clients put in 2 Jackson affidavits addressing those points. That, first of all, let's focus on what he testified to. He testified he fell in a grassy area. He fell and his foot went into that grassy area. So there's a question as to whether or not there is even a visible defect here. It's not categorical that there was a defect here. With regard to the pre-inspection reports, we have 2 Jackson affidavits. My client said there weren't any pre-inspection reports. They searched their home, they searched their files. They don't have any of that information.
But
We're not refusing to.
Counsel, I don't really understand that argument, because the affidavit's in. Why isn't the defendant entitled to now look for in other places to at least attempt to get that information?
Because there's no indication as to how these inspection reports are going to lead to information about this latent defect.
Is that
This
necessary?
area happened, it happened,
Is that necessary?
yes, I believe it is, because it happened in a grassy area in front of shrubs, in front of the house.
That goes to relevance. That goes to whether or not it might be relevant in trial, and it might not be relevant in trial. But it doesn't go to the issue of whether or not that discovery is material or necessary, or as my colleague said, it may lead to relevant material.
Other than a photograph, it cannot lead to anything, because a pre-inspection would be of the stairs, would be of the roof, would be of things of the house.
Well, I mean,
There's no indication that the
counsel,
grass
you're-
was going to
but-
be inspected.
Suing the company that did the work here, why are they not
The
entitled?
third-party defendants went in there and performed all this excavation work after the home was purchased. They went in there and dug this area all up and then remediated it. So the only thing that could be relevant here would be a photograph. Here's the hole the plaintiff fell in. Let's see if that hole existed 6 months ago. That I understand. Other than a photograph, none of this material would be relevant in terms of what happened in this.
But relevancy
Doesn't it
is
have to
not.
be- Go ahead.
I'm sorry, go ahead.
Doesn't it have to be palpably irrelevant? It's not just what you think is irrelevant. It's like palpably is usually added to the word irrelevant in these discovery disputes. And so I really don't see this. I see this as stonewalling. And if I was the trial judge, I would have really been suspect of your client's behavior, because they couldn't remember their real estate agent's last name. They couldn't remember the lawyer who represented them at the closing. They couldn't remember their mortgage company. That's ridiculous.
I believe that Countrywide was turned over, so I think that's inaccurate. Let me
But
correct
they
that.
initially stated that they could not remember.
They
And
were-
also,
they
how
were
do
put
you
in-
how do you not remember the names of your realtor? I mean, that doesn't make
And
any
the bank
sense.
that holds your mortgage.
Yeah, I mean,
There's no evidence that this area was inspected by anyone before this accident happened.
But that's what we're
They
trying
went in there
to.
and
That's
dug it
what
all
they're
up.
trying to figure out.
turn it
That's what they're
over.
trying to discern by asking for the discovery.
What you're basically saying is that you want the courts to just say, well, your client says, well, I don't know, and that's acceptable. But that's not what the law says.
But dozens of photographs have already been turned over. Dozens of photographs, pre-listing photographs, have already been turned over.
But again,
They were
those
asking for
arguments-
canceled checks in this.
Counsel, it may be cumulative, but that's not the objection that's appropriate at this juncture.
But they're not articulating what it is they think this is going to lead to, other than a photograph. I'm not disputing photographs, which they already have a dozen of. A canceled check, an inspection of the stairs, an inspection of the roof. What is it they're looking for? They don't
Because then we'll
articulate how
know
any
the
of that's going to
company,
lead to
we'll
how this
know the
accident-
mortgage company, we'll know in the agent, and perhaps the agent took pictures. I mean, again, the issue as to relevance is not an issue as to relevance right now. The issue is as to discovery and whether or not it's material and necessary to the prosecution of or defense of the action.
The third-party plaintiffs went in the area and dug up the area. So what would anything show? They went in and dug it all up.
But we don't
What
know.
is something going to show in March of the year of the accident if they dug it up in July? It was all dug up by their contractors.
We don't.
Maybe nothing. but
Right.
They get a chance to find out.
We don't know at this point. Thank you.
Thank you.
Your Honors, I would like to respectfully clarify certain points. My client, J. Fletcher Creamer, Royce, excuse me, I cannot pronounce his last name and I don't want to slaughter it. He testified that they did not dig up the complete area when performing their work. They more than likely dug under, performing, in essence, a tunneling. So if this tunneling did in fact happen where the subject depression was, it may not have caused the depression itself. It could have exacerbated it. However, without these photographs, we would not know if the depression itself existed prior to my client's work. Moreover, the notice of claim did have photographs which did show a depression. However, this notice of claim and the photographs, once again, post-date the incident. Ms. Moreno also testified that prior to purchasing the home, that there was someone who would perform work in the area. I believe she said her name was Carol. They retained her after their purchase to do the grass mowing, since she worked in the area before, in essence, mowing the lawn. It would go to constructive notice that depression would have been visible.
Thank you. Romero v. the City of New York.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. It's our position on this appeal that under the burden-shifting paradigm of matter of Newcomb, the plaintiff met their initial showing of a plausible argument, and shifting the burden, defendants did not establish with particularized
What
evidence.
was the reasonable excuse here for not filing a timely notice?
Well, the reasonable excuse clearly doesn't save the day, but what it was that the plaintiff was
You call it a disabling injury.
busy with her medical injury. She did not submit medical documentation. We recognize that. We understand that she should have done that under the
But
law.
how does that, aren't you in essence acknowledging that the prima facie case wasn't made out because you don't even submit any evidence corroborating what you're saying?
Well, our position is that if the reasonable excuse factor isn't met, it's not fatal because the prejudice factor is in our favor. And so you could have a situation, we don't even have actual notice within
Well,
the
in the
90 days.
cases that talk about, that there's no prejudice to the defendant, there's usually a police officer who might have been on the scene taking notes or something. This is an accident, and from what I can tell, no witnesses, at least from the party that needs to be notified. So how is there no prejudice? I mean, so much time has passed. We're talking about witnesses that might have been needed to be spoken with, or inspections that might have needed to be made. How do you show there's no prejudice?
So our position with regard to that and our initial showing is that 4 months after the expiration of the 90 days, I know we don't have to wait 90 days, but it was 4 months late. This was not a transient condition. This was a roadway deterioration defect, and that usually they don't get better, they probably get worse. And there was no indication, which is on the city to establish under this court's case law, that they undertook any investigation. They can't claim prejudice if they didn't undertake an investigation. So in June of 2022, when the notice of claim was filed, they could have gone down to the accident location and determined whether it had changed.
Let me see if I follow your argument. They didn't undertake an investigation for an accident that they didn't know happened?
Well, they knew in June of 2022. They knew 4 months after the expiration of the 90 days. So our position is at that point, considering it's not a transient condition, it's not like snow and ice or something, this is a roadway defect.
Under our case law, aren't sidewalk and street defects considered transitory conditions?
Well, I found one case from 1995, actually, where
Right,
it
that's
said,
Turkinitz.
yeah, it was a very interesting case because it wasn't cited.
Which specifically stated that sidewalk and street defects being transitory in nature must be promptly investigated. At least the passage of time make it impossible to reconstruct the circumstances existing at the time of the accident.
That's true. And then there are other cases more recently, like matter of Richardson and Green against City, and actually one that you were on. I think it's Ebony B, Judge Weber, but that their sidewalk defect cases, if they're likely not to dissipate over time because it's a roadway or a defect, as opposed to something like dirt or debris or snow and ice. So I can't really understand why that bench.
Well, there was one that was a metal plate, right? I don't remember.
Yes,
which one. It
well,
was a metal.
in Silva, it was a metal plate.
Right, Silva was a metal
Silva was a
plate.
metal plate. But here, I know we don't have any photographs, but that's my point. What prevented the city? Nothing. And what were they supposed to undertake? They were supposed to undertake an investigation. In fact, this court said in Pearson, once a municipal body receives a notice of claim, it has actual notice that a lawsuit is likely to follow, and it should begin its investigation and preserve evidence, even if the notice of claim is served late. So our position is, even though they didn't have knowledge within the 90 days, they had knowledge 4 months after the expiration and did nothing. They can't claim prejudice under this court's precedent. They did nothing. And should I take this up on reply?
Yeah, just finish your thought.
I'm sorry?
Finish your thought.
Okay, thank you. In opposition to our petition, all they claimed was your notice of claim was late and we have prejudice, but we know that prejudice isn't presumed. They did not contest the assertion that this condition didn't dissipate at the time that the notice of claim was filed. So that's why our position is a burden shifted and they didn't meet it. And they're supposed to come forth with
You're
evidence.
beyond your thought.
Thank you, appreciate it.
Good afternoon, Your Honors. John Chapong on behalf of Respondent, City of New York. I think it's important to remember in this case, petitioner wants to talk about prejudice, but this was a leave denial, and the standard is abuse of discretion. And we have a practically conceding, counsel's practically conceding they don't meet two factors, reasonable excuse or the actual knowledge.
Well,
by
we
the
do
city.
have cases that say that showing lack of a reasonable excuse is not necessarily fatal. So in light of that, how do you now respond?
That's right, Your Honor. It's not necessarily fatal, but what we have here is the Supreme Court exercising its discretion to deny a leave application here. And I'm not aware of any case from this court where there was a reversal as an abuse of discretion where those two factors, there's not even an argument.
Well, they concede there was no actual notice, but there appears to have been some type of constructive notice, right?
No, Your Honor. There was notice at the time.
At the time of the late filing.
There was no actual notice during the period of time, and
Right.
What about this issue of 4 months after the notice of claim? Is that sufficient?
No, Your Honor, and for a number of reasons. Number one, it's not a reasonable period of time because they don't even make a serious argument about there being a reasonable excuse for this period of time. And if you want to talk about the defect and prejudice, this is not something that is. I would just point out that petitioners want to ignore the burden shift here. That Newcomb places the initial burden on the plaintiffs here.
I think I heard your adversary say that in fact the burden had shifted. So why didn't it shift?
That's right, Your Honor. They claim that it shifted, but it didn't because they submitted absolutely no evidence of any lack of prejudice here. There's no photos, there's no videos, there's nothing.
No actual notice here, right? And a lot of the cases where we say we sort of slough on the prejudice, there may be actual notice, for example. So hence, hard to argue prejudice.
That's right, Your Honor. So in the cases that I'm aware of, there is indications that there was actual notice within the relevant period, and here there was nothing. So this isn't. I would just emphasize that this is a roadway defect. This isn't a case where the information is solely within the city's capacity or something like that. Petitioner wants to say that we should have gone to take pictures. They also could have gone to take pictures to meet their initial burden of showing a lack of prejudice, which Newcomb is very clear. In Newcomb, there were photos in that case, and that's why the burden shifted to the respondent.
So at the point that you actually received the late notice, was there any burden on you to investigate at that point in time?
No, Your Honor, because there was neither any argument about this being transitory, and petitioner disputes this in their reply, but I would challenge them to point to anywhere in the record where they actually state that anything about this defect is not transitory. It's a roadway defect, which this court has stated repeatedly, and we cite Turkinitz in our brief.
I'm not sure repeatedly. There
are at least two
case
instances
out there that supports your position.
There are at least two instances, Your Honor, Turkinitz and McKee, and we cite them both in our brief. But the point is, they're trying to basically render Newcomb dead letter by saying that just citing a roadway defect means that they have met their initial burden under Newcomb, and that's just not the case, Your Honor. They have to establish a plausible argument, or they have to show proof that there is a lack of prejudice here before the burden shifts. And they didn't even make an argument in Supreme Court about prejudice. They said that they gave a laundry list of contradictory adjectives about this roadway defect, which themselves demonstrated that there was prejudice here. They're talking about deterioration. Counsel says that maybe the defect could have gotten worse. That's a concession of prejudice, Your Honor, because that means that the city is unable to go to this location after the 8 months have passed and see what it actually looked like at the time that the petitioner says that this incident occurred. That's prejudice, Your Honor. And so I think that all we're asking for in this case is just this court to adhere to Newcomb, require them to show an initial burden before there's any kind of burden being placed on the city.
Thank you.
Thank you, Your
Honor. On page 11 of the record, paragraph 12, the plaintiff petitioner did talk about matter of De Silva with respect to the condition not dissipating. So it's preserved. It was discussed below with regard to that case. But if you look at Green, so Green against City of New York, both in our briefs, matter of Richardson, they both deal with sidewalk cases. And in both of those cases, this court said, in Green, we have repeatedly held that municipalities must put forth at least a modicum of effort to investigate a notice of claim. Here they did nothing. In matter of Richardson, although NYCHA did not receive actual notice of the accident until the petition was served, it did not contest petitioner's assertion that the condition of the badly broken sidewalk remains unchanged since the time of the accident, and that there were no witnesses. Nothing came from my adversary below.
Your argument really is underpinned on the notion that, that the burden has shifted, right?
It is, and yes.
And so sort of going back to that, generally where we say no prejudice, aren't those in cases where there's actual notice?
Not always, because I think if you look at Newcomb, it talks about the or. There's an or. So you can produce evidence or you could have a plausible argument. So in that regard, it would be, yes, in those cases with notice goes hand in hand with prejudice. I understand that, and it's true. But my adversary was incorrect. I don't have time. It's in my brief that you have several times. Matter of Richardson is one of them where there was.
Well, in Richardson, though, NYCHA didn't contest the fact that the sidewalk was unchanged. They never contested that in Richardson.
Correct, and I'm saying my adversary didn't contest that below here, that it wasn't changed. That is my point, to say that he in opposition to the petition, he could have, had they gone and done something.
But also in Richardson, I thought that the petitioner also produced photos, which you did not do.
I understand we didn't produce photos. I understand it would have been better. It would have been better practice if we produced photos, and it would have been better practice if we produced the medical documentation to support. However, all four not one factor dominates, and I think that if you're looking at it holistically, and if the plaintiff has made a plausible argument and the burden shifts, the defendants have done nothing in response.
We're back to the burden shifting.
We are.
Thank you. Thank you
so
both.
much.
Sullivan v. New York State Division of Human Rights.
May it please the court, I am Robert Sullivan. I represent the petitioner, Catherine M. Sullivan. This is a special proceeding pursuant to Article 78 and Section 298 of the Executive Law, seeking to annul the final order of the Division of Human Rights, dismissing the petitioner's complaint before the division, and making a finding of discriminatory conduct against Liberty Mutual. I'm sorry?
Thank you. How do you get beyond the Grant and Osorio testimony that the petitioner struggled with testing and work requirements, and her work required review or correcting, and that would be a non-discriminatory reason for their decision to terminate?
Well, I suggest, Your Honor, that, and quite frankly, it's found by the hearing officer, the issue of her struggles. If you take a look at the minutes of all the meetings and where they're coaching her, all of those came post her seizure, magically came out when she announces that she's got to go for cataract surgery. But most of these so-called struggles are pretty de minimis. She can't upload files to a Z drive.
But counsel, this is a substantial evidence case, I mean, which is a very difficult threshold for your side. So isn't that enough evidence?
It isn't, Your Honor. I think in this particular case, and as we argued, I think in our reply brief, if you take a look at the basis and the evidence that was offered to rebut the presumption of discrimination, it's based on the same evidence. I mean, all of this time-wise and timeline-wise occurred after the seizure. It all started in August or September, and there were conversations between human relations, Ms. Harding and Ms. Ray, talking about, well, you know, we got to start documenting things. And I suggested to Your Honor that even if there is evidence to rebut the presumption of discriminatory conduct, this looks pretextual. It starts out with meetings. Oh, we got to start documenting this thing. Why if she's an employee at will and she was incompetent, as even before her seizure, as they've suggested without evidence, then they should have just fired her. Why are we going through?
That doesn't make any sense to me. Why would a company do that rather than trying to educate, teach people how to, for example, upload documents, or maybe try to teach your client how to use the Liberty Mutual claims platforms?
Yeah.
Isn't that a better practice than just immediately firing someone?
Yeah, but we get to the premise of, was she really incapable of doing these things? Remember, there's evidence in the record by her coworkers when they were training her when she initially started. They said, well, you know, she wasn't great at working on Microsoft, but, you know, she was satisfactory. And, You know, so all of the seeming defects. Remember, this is somebody that's been in the insurance industry for 31 years. Her prior job, she worked for 14 years. How did
This is
she
a new
all of this?
it's a new platform that she's learning. And that was the whole point, was that it required certain additional skills, certain additional computer skills that she was being trained. And the Osario, and I forget whoever, the other witness stated that they made several attempts to assist her, and she just wasn't getting it.
Yeah, but in the testimony, no, it wasn't. The only one that said she wasn't getting was Harding. Osario and Grant, in their testimony, they worked with her, and she seemed satisfactory. They had corrections
Didn't
for her. and
Rosario
training.
also testify that petitioner struggled with routine tasks and needed training?
I'm sorry, Your Honor.
Didn't Osario also testify that your client struggled with routine tasks and needed more training?
That was prior to the seizure, but she never made any commentary on that to Harding or made any report of that, and there was just nothing documented.
She said that petitioner struggled with routine tasks such as saving documents, uploading files to a shared drive, using Word and Excel throughout the employment.
But if that is so, Your Honor, then the finding that there's a presumption of discriminatory conduct found by the administrative law judge is inconsistent, because all of that was pre.
Osario also stated she didn't know how old your client was or her date of birth or anything of that nature.
Of course she didn't. But what I'm saying, Your Honor, is the administrative law judge who heard the evidence made a finding that there's a presumption of discriminatory conduct subsequent to her seizure, and he laid that out in the record as to his findings in that regard. So
you have time on rebuttal. Thank you.
Okay, thank you, Your Honor.
Good afternoon, Your Honor. Simone Francis on behalf of Liberty Mutual Group. We respectfully submit that there was substantial evidence to support the findings of the administrative law judge, which were contained in 92 findings of fact supported by an explanation of law. While petitioner asks or states again that the request is to annul the findings, it's noteworthy that they do not challenge the ALJ's rejection of the hostile work environment claim based on disability or age, and they do not challenge the finding that the temporary period during which she...
Counsel, on this issue of pretext, your adversary indicates that the timeline would infer that all of the objections to her work performance came after the seizures and the cataract surgery. How do you respond to that?
Yes, as the ALJ found, the early part of her period was of her employment was deemed a honeymoon period. This is not a case where petitioner sought an accommodation, so it's not a failure to accommodate. The argument is once she came back to work, she was fully capable. And yes, while there was an intervening period of illness, that does not demonstrate causation. As the ALJ properly found, there was a demonstrated record in which she received a verbal warning. It was reduced to writing. Then there was a written warning. During this period, Harding, who had worked for a predecessor entity, appropriately consulted with Human Resources to determine the proper procedure, and then followed it all the time, counseling the petitioner and engaging in coaching sessions. So the mere fact, while the ALJ did find that she had made her prima facie case, he also determined appropriately that there was a legitimate non-discriminatory reason, namely Ms. Harding's concerns about her performance. Ms. Harding was obviously her supervisor, the person to whom she reported, and those concerns were founded in the very tasks that were identified in her job description. Certainly as a matter of law, the ALJ did not, and this court would not sit as a super personnel department to second guess Ms. Harding's and the respondent's view of her performance, and that was documented.
Your adversary suggests that the documentation essentially was just a way to paper up the case before firing her. What's your response to that?
My response, Your Honor, is that there was a policy that suggested, as Your Honor indicated, the appropriate path of coaching and working with an employee before they are terminated. And that is far from being papering up. The fact that they followed that procedure demonstrates that the reasons for the termination were not pretext. That would be my response. On the age discrimination, the evidence was that Ms. Harding and the petitioner were a mere 4 years apart. The ALJ appropriately found that again, there was a legitimate reason for her termination. Thank you very much, Your Honors.
I'll waive the rebuttal, Your Honor. I'll rely upon our brief.
Thank you. Thank you both. Khan v. Garg. Yes, you may proceed.
Good afternoon, Your Honors. Rachel Karich on behalf of the plaintiff appellant. From the outset, I want to ensure that it's clear that although plaintiff summary judgment appeal and motion to renew appeal were consolidated for judicial efficiency because the facts overlap, they are still separate appeals with different grounds for reversal. The defendants mistakenly conflate the two appeals by arguing that in order to prevail on this appeal, plaintiff must show that the settlement should be set aside, and if the settlement is set aside, there is a material question of fact on the misappropriation claim.
I'd like you to focus on the release. Does the release in the settlement bar the breach of fiduciary claim?
No, it does not. Well, this is where we need to parse out what the different breach of fiduciary duty claims are. With respect to the breach of fiduciary duty claim on Mr. Khan's for the misappropriation of the IP, that breach of fiduciary duty claim, that assumes that the ACES settlement is in fact valid. And when in the face of a valid settlement, then you have to look to collateral estoppel. And the lower court got the analysis of collateral estoppel incorrect. Specifically, collateral estoppel.
Collateral estoppel is just a release. It's not collateral estoppel. It's just this is a release in a stipulation, which is a contract.
So with respect to the release, no, our position is that it doesn't bar the breach of fiduciary duty claim. And the position of the defendants has been that it does, in fact. It's so broad that it would.
They'll explain their position. Why is it that you're saying that it doesn't bar your claim?
Why does the release not bar the breach of fiduciary duty?
One of your arguments, at least on renewal, is that it should be set aside. That kind of thing. Is that the gravamen of your argument here today, or something different?
No, Your Honor, that's different. So that's why it's important to parse out the different breach of fiduciary duty claims, because there's multiple subcounts underneath the breach of fiduciary duty claim. Now, with respect to the breach of fiduciary duty claims surrounding the ACES settlement, that does assume that the settlement agreement is in fact invalid. And that's an important distinction. Whereas the breach of fiduciary duty claim for the
Didn't the Supreme Court approve the settlement agreement?
The Supreme Court did approve this.
And this is, I'm going back to many years ago, and was there ever an appeal taken from what Justice Owing did?
No, well, there was a procedural issue, and so.
Well, just yes or no?
No, no, there was not.
So today we have, or at least the posture is, that there is a Supreme Court judge who approved the settlement, and it's my understanding, at least reviewing it, is that the basis of the approval was the expert report, correct?
That's correct. And, well, this goes to the renewal motion, which again, it's different grounds for reversal because it assumes the settlement is invalid. There's been ample evidence that's, we consider new evidence, showing that there was contradictions that were made to Justice Owing when he was approving that expert report. For example, I think one of the most salient ones, which can be found on page 21 to 22 of our brief, is Mr. Johnson's testimony about EIFC's algorithms and data. In the arbitration, the defendants claim that after leaving EIFC, Mr. Johnson created a new system from a blank state, and he did not create a new iteration of the previous programs. However, Most recently, when testifying about EIFC's algorithms in the trustee action, Mr. Johnson testified that after he left EIFC, he focused primarily on revising the algorithms and updating and refining data sets. So if Mr. Johnson was merely revising and updating and refining the intellectual property that was used to service the TRIAC CDOs after he left EIFC in 2013, then what was the entirely new system he purportedly built from a blank state that Dr. Liegler reviewed? The same holds true for the data. Dr. Liegler found that there was no theft of EIFC's data, but in the arbitration, the defendants took the position that EIFC used CoreLogic to service the TRIAC CDOs, and then when they went to the new company owned by defendant Garg, they used a new data set. However, when testifying about EIFC's data in the trustee action, Johnson swore that at EIFC, they reviewed data from CoreLogic, but ultimately decided to go with a different data company. So again, this begs the question, was Dr. Liegler reviewing data from DataQuick or CoreLogic when he opined that EIFC's data was not stolen? If the source of the materials reviewed by Dr. Liegler is unknown, how could he opine that EIFC's misappropriation claims were meritless? A jury should be allowed to consider whether the answer to these questions eviscerates Dr. Liegler's entire report, an extra report that was relied upon, as you mentioned, by Justice Oing in approving that settlement.
Thank you. You have time on rebuttal.
May it please the court, I appear today on behalf of respondents.
So, counsel, what's your spin on the release?
I mean, I think the release issue is very simple for this court, Your Honor. It did release Mr. Garg. The lower court found that it released Mr. Garg, and Mr. Khan never appealed that ruling. And that wasn't in the briefs. It has.
So on renewal, and I think the arguments are you have to look at both both motions together in some sense. On renewal, plaintiff argues that the settlement was a product of fraud. How do you respond?
There was no fraud here. The fraud claim, it's very surprising. Essentially what they're saying is, in order for there to be fraud, there needs to be misrepresentation. Their misrepresentation is this supposed ownership, who owned the property. And in order to succeed on their fraud claim, they need to show that Justice Oing relied upon this misrepresentation, and under the renewal standard, that there would have been a different outcome had this misrepresentation not been made. Justice Oing was very clear in his decision what he was relying upon. He said, I'm relying upon Dr. Liegler's expert report. Dr. Liegler went out of his way not to address the ownership issue. Dr. Liegler spoke exclusively to the issue of was there misappropriation or was there not misappropriation, and he concluded that there was no misappropriation whatsoever. And at the end of the day, that is what this case is about, and that is why I think Justice Oing and Justice Masley cut to the heart of this case. There was no misappropriation.
Now in this case, Sherman and Sterling was independent counsel, correct?
Correct.
And it was Sherman and Sterling then who retained the expert?
Correct. And to be clear, Dr. Liegler, in addition to being a Rhodes Scholar, has a PhD in computer science from Oxford and was a practicing computer science for 39 years. And these algorithms that they're saying were stolen, they're really just software code. So they're these lines of code. And all Dr. Liegler did was took the code that EIFC claimed that it owned, and it took the code that EIFC claimed was stolen and compared the two of them to each other and said, hey, the second code was not copied from the first code and the second code was not derived from the first code. And they made really no effort to rebut that. They offered the opinion of Mr. Vanilla. Mr. Vanilla is a finance person who works for banks. He's not a computer scientist. He did not even bother to compare the code at all, and that is why.
That presumably would be outside his purview, correct?
Correct, but that was their response to Dr. Liegler, was Mr. Vanilla, and my point is the Dr. Liegler, who was an independent expert, completely debunked the concept of misappropriation in this case. They never responded to it, and that's really why their case came to an end.
Counsel, the IAS court analyzed these issues under New York law when Delaware law, it seems to me, should apply. Does that make a difference?
It makes no difference whatsoever. It makes no difference for two reasons. One, Delaware law is the same as New York law on this issue, which is that the trade secret statute in Delaware absolutely preempts any claim for misappropriation of information if the information is not a trade secret. The second reason that doesn't matter is because here there was no misappropriation at all. The preemption issue only comes into play when the question is, was it a trade secret misappropriated or was some non-trade secret misappropriated? And here, because there was no misappropriation at all, the Delaware versus New York law issue is just, it's a non-factor.
In other words, there was no misuse of the intellectual property.
Correct. I'm happy to answer any other questions that the panel may have. Otherwise, I'll rest.
Thank you.
Thank you.
Counsel, just to pick up a thread that your adversary started out with, the Dr. Ligler issue and him being an independent expert, the response to that from your client, how do you address that you don't really have somebody comparable to Dr. Ligler who purportedly is an independent expert?
So the problem here is Dr. Legler wasn't provided with the full deck. He was provided with the materials that were controlled by Defendant Garg, and Defendant Garg did not give him all of the materials.
Did you raise those issues before Justice Oing?
We couldn't raise those issues before Justice Oing because discovery had not commenced at that point. We didn't know. And we also didn't have the trustee action testimony, which just happened in 2023.
What do you mean you did not know? You would have known what he relied upon.
With respect to Dr. Legler, no, we didn't because discovery hadn't happened. So
did his report not state what he was relying upon?
it did state what he relied upon, but then we needed to actually see the underlying materials and because the defendants refused to produce those materials, we actually had to serve a third-party subpoena on Dr. Legler. And when we got the actual hard drives and saw the software code and the algorithms and the data and everything that he was looking at, Mr. Vanella said—
When was that? Was that a couple years after Justice Oing issued his decision?
Oh my goodness, I'm so sorry. This is going to date me a little bit, but
but
it was years ago.
Okay, did you make a motion to renew once you obtained that information, saying there's new evidence here and Judge Oing, you got it wrong?
No, at that point, that's when we were opposing the summary judgment decision. And then we made the renewal motion once the new facts came.
One is not, exclusive of the other. So again, if you found after however period of time that Legler relied upon things that he should not have relied upon, I'm not understanding again why you did not make a motion before Judge Oing.
Well, Justice Maisley had taken the case over.
Okay, before Justice Maisley.
And at that point, we did make, the new facts really came to light in the trustee action, which reinforced our points insofar as the defendants were dishonest with the trial court. And if I can please just very briefly, I do want to address my adversary's point that Delaware law on breach of fiduciary duty is not that whole argument that it's the same as New York misappropriation law. That is incorrect, and it is incorrect under precedent in this court, and that is the Schroeder v. Pinterest case, which specifically says that a breach of fiduciary duty claim for misappropriation IP is separate and distinct from a misappropriation of trade secrets claim. That is well-established case law. They're not the same. They are very different, and that's in our briefs. And I think that that error by the lower court is very clear.
Thank you.
Thank you, Your Honors.
Moberg v. Phoenix Cayman Limited.
Good afternoon, Jason Burland, counsel for Appellants Phoenix Cayman Limited, the GP in this case, and Vishal Garg, the director of the general partner. Since 2020, Ms. Moberg and 3 other limited partners of the Phoenix Holdco partnership have been using a separate action, Black v. Phoenix, to extract money from Mr. Garg to which they have no conceivable right, as the LPs have already received more than their initial investments plus 8% returns of an investment as investors in the partnership. Now, as discovery in the Black case came to an end, the LPs manufactured a contrived claim that Phoenix Cayman, the GP, breached its obligation to provide the LPs with certain financial statements, and they used this manufacturer claim to try and force out Phoenix Cayman as—
Before we get to the merits, don't we need to talk about the April 28th letter, right? That's a necessary predicate for bringing a lawsuit.
Yes. So there are 2 reasons why this letter, the Moberg letter, we'll call it, was deficient. First, the LPs failed to comply with the express requirements of the LP agreement that they provide the general partner with a notice from the partnership of the so-called breach sufficient to trigger the contractual 30-day cure period. Now, Section 6.1D of the LP agreement, it's at appendix page 177, states the GP may be removed with cause upon affirmative act of a supermajority in interest. Now, the LP agreement goes on to state in the definition section, page 214, that cause, and this is important, cause means the general partner has committed a knowing, willful, and material breach of the agreement that is not cured within 30 days after the GP's receipt of notice from the partnership.
But we don't even need to get to that point because this letter doesn't necessarily come from the supermajority of, as detailed in 6.1, the notice requirement.
Well, that's the whole point, that this letter just comes from one LP, not from
She's a limited partner.
She is one limited partner.
And does the letter in any way indicate that she is sending this on behalf of the partnership?
No, in fact, it does not.
Does it use the words notice or breach?
No, it does not. So what we have here, and exactly to what your honors are noting, is a letter solely from Ms. Mulberg on April 28th. It contains none of the contractually necessary language to suggest it was from the partnership. It begins with the words.
Counsel, would it be fair to say that it was really essentially a demand for audited financials?
You read my mind. It was a document demand, and in fact, it was a document demand. That's right. That was the first problem with the letter. The second problem is that the trial court erred when it summarily concluded that the Mulberg letter sufficiently identified the existence of a breach. So we have that it's not from the partnership, and it doesn't even, as the LP agreement requires, state that there was a breach. There was no plausible basis to reach the conclusion because the Mulberg letter does not contain any language suggesting it was alleging a knowing, willful, and material breach.
Did it reference the contractual removal provision?
Excuse me?
Did it reference the contractual removal
It did
provision?
not reference anything. It was, again, just a simple demand letter, and that's the problem. The Mulberg letter was at most a document demand, as can be gleaned from the subject line, which reads demand for audited financials, as well as the closing paragraph, which states a demand is hereby made that the general partner distributed audited financials.
So therefore, the letter did not provide sufficient notice to trigger the removal of the partner.
And that's why we think Justice Ostrager got it wrong, and that why this case should have been dismissed at the motion to dismiss stage.
Let me just ask one more question on this point before you move on. The part of the letter that references the January 23rd request made by the general partner, that doesn't, does that help or hurt your argument?
It's almost irrelevant. So, you didn't ask, but the judge went into this, which wasn't prompted by anybody in their papers, attendant circumstances. Frankly, even if the court could have properly looked at attendant circumstances, such as these two January 2023 letters, all those were document demands by two additional LPs. When you take those two letters and Ms. Mulberg's letter combined, that's 3 LPs out of 15 writing requests for documents, a document demand. That's all this really is. So because the Mulberg letter does not come close to satisfying the notice requirements under the LP agreement, the trial court should have concluded that Ms. Mulberg and the other LPs' efforts to remove the GP and replace it with Blue Bear, controlled by the LPs, was invalid, and that plaintiffs therefore have no viable claims and the complaint should be dismissed.
Thank you.
Thank you.
May it please the court, Rachel Kirich on behalf of the plaintiff's respondents.
So counsel, how do you get around section 6.1?
So section 6.1 does not state that the notice has to be...
6.1D, rather.
6.1D, it doesn't state that the notice has to be sent from the supermajority. It just says that it refers to cause, and within cause, the definition of cause states that there needs to be a notice from the partnership.
Okay, so let me stop you there. Who sent this notice?
Ms. Mulberg, who is...
And how did she identify herself I'll use your words, in the notice?
In the letter, she states, I am right, well, first off, the reline says Phoenix Holdco LP, demand for audited financials from Phoenix.
So doesn't that sound, if I were to get that letter, wouldn't that tell the reasonable reader that this is just a demand for audited financials and that's it?
No, I actually, respectfully, I don't agree with that because, and I do think that Justice Ostrager got it right by...
Why do you not agree? It says demand for audited financials from Phoenix Cayman Limited.
Understood. That's the beginning. But then if we continue to look at the rest of the substance of the letter, it specifically delineates the provisions that the GP was required to comply with, particularly what's at issue here and what is most important.
Well, let's back up for 1 second. It also states, I write regarding the books, records, financial statements, and other reports of Phoenix Holdco Limited. It says I write. It does not state we write, which would be the partnership. It makes no reference to the partnership. It says I write.
Well, if we are going to, I do believe from a general perspective, we do need to keep in mind that no matter what this notice said, one way or another, if it checked every single box that the respondents have complained about, the respondents, or excuse me, the defendants were never going to comply with this notice.
But before, we don't know that. We don't know that, right? Isn't the purpose of a notice to cure is to put a party on notice, hey, you got to do something in 30 days or drastic action will be taken.
Yes, that's fair.
So what in this notice gives Mr. Garg that he's required to comply within 30 days?
Well, that's if we're discussing strict compliance. There are exceptions to strict compliance. One of those is futility, insofar as somebody has abandoned performance, which is exactly what happened here, or if there was an incurable breach, which is also what the GP has claimed is we couldn't get an auditor because the other one resigned and there's these disclaimed financials, so they were never going to comply, no matter if this
Counsel,
notice
there
was
might be a
perfect.
different issue if we had a different notice letter, if it said something different, if it didn't just reference the demand for the books and things of that nature, if it was writing on behalf of thus amount of people, not necessarily signed by the individual as the estate for the person who was the LP. So, I mean, we have all of these defects in this particular letter. It might be different if it had something else.
I understand that, but so let's say, let's take just the one that it's from Ms. Molberg. If you look at the plain language of the LPA, it defines the partnership as Phoenix Holdco LP. So that's either going to mean one of two things. It's either going to mean that it's the LPs, and it is perfectly reasonable that one LP, being a part of the LPs, could send the notice, or it's going to mean management.
But she doesn't even say that she's writing as an LP. She signs it as Caroline Molberg, executor of the estate of Eric Molberg.
She would have no reason to send this just in an individual capacity, writing to.
That's not the issue. I mean, there's a reason why we have this section in the agreement. You know, you can't just say, she can't just sign it as, signed by Caroline individually in her capacity as executor. Again, it says, I write regarding. Again, there has to be notice that it's on behalf of the partnership.
Well, I think that is, and a question that was asked, and please, if I could just have a minute to address this point, is that the January email thread was incorporated by reference into this notice. And the January email thread is very clear that these requests are being sent on behalf of the partnership. Mr. Amori is very clear about that. Ms. Molberg then follows up and says, this is a breach of your duties to not provide annual financial statements. And then in response to the April 28th notice, this is so important.
Let me just make this one point before we get to your response, is that in the conclusion of this letter, Ms. Molberg again says, demand is hereby made for distribution of audited financial statements. Again, it sounds like what's being requested are audited financials.
So let's look at the GP's response to the April 28th notice, because I believe this is very, very important. Phoenix Cayman's authorized representative responded to all LPs in response to the April 28th notice. He didn't respond to just Ms. Molberg, and he is, Mr. Marin, he is an attorney. And in that email, he acknowledged that the April 28th email cited a default stating, as an initial matter, the general partner has not denied any request for financials. His email then goes on to admit that the 2021 audited financials had not been prepared and the GP had not even engaged an auditor. They knew that the breach was incurable. They knew that they needed to cure it, and therefore strict compliance should be forgiven, especially in instances of abandoned performance and where there's an incurable breach.
Thank you.
Waive my rebuttal time and rely on the papers unless there's questions from.
Well, I do have a question. What about your friend's statement that because you did in fact reply stating that there was no breach, et cetera, that you were acknowledging that it was in fact from the partnership?
I think it's apples and oranges. The fact that there was a response and ultimately audited financials were turned over doesn't change the fact that this is a very narrow issue, this case before your honors, whether or not the notice was proper. And for all the reasons I argued, notice was not proper. I think the fact that there was a response doesn't change the fact that Justice Ostrager erred in his decision that there was proper notice.
Thank you.
Thank you.
both. People v. Shamel Rodriguez.
Good afternoon, and may it please the court, Barbara Zolot for Appellant Shamel Rodriguez. I'd like to address the masking issue and the juror misconduct claim. Turning to the masking issue, the trial court violated Mr. Rodriguez's statutory and due process rights to participate in jury selection.
You rely on Ramirez, of course, on this issue, correct?
Yes, correct.
But does Ramirez say that it's a constitutional floor?
No.
In other words, I know the procedures used in Ramirez did include a clear plastic mask when the veneer people were being questioned, correct?
Well,
Is that right?
yes.
And that didn't happen here, so it arguably is more, it helps you, is more revealing. However, did any place Ramirez say, and this is the lowest we're going?
It doesn't directly say it, but I think that is absolutely the thrust of the court's balance, what the court said about the balancing that it did. What the court did, after stating that there was no error in allowing the jurors who weren't being questioned from being masked, that was actually the holding of the case, that that's not error. The court then went on to state that what the lower court had done was a proper balance of the defendant's due process rights against the safety considerations by allowing the defendant to fully see the faces of the question jurors, even if I'll point you to where it is in the case, even though the jurors could not fully see the faces of the jurors who weren't being questioned. So central to the court's determination that the balancing was proper was the fact that the defendant was able to fully see the faces of the questioned jurors.
But the court also went on, and Ramirez also talked about the fact that there are many ways to evaluate jurors, right? And so in terms of the mask, I mean, you still see the eyes, you still see body language, you still see the voice, et cetera. So why is that not sufficient in terms of evaluating the jurors?
I think the case really needs to be read carefully, because when the court said that, it was talking about whether it was a violation to require the jurors who weren't being questioned to be masked. And it was in that context, when it was assessing that restriction, what was actually presented in the case, that the court said, well, this is a slight restriction because these aren't the jurors who are being subjected to questioning. And the defendant has no right to simultaneously see all the jurors, both the jurors being questioned and the jurors not being questioned.
But the court also talked about balancing the need to protect the health and safety of all parties and court officers during the pandemic mask mandate.
Absolutely. I mean, these balancing considerations were at issue.
And when I say the court, I mean the Court of Appeals.
The Court of Appeals, right. And what's important about that balancing, this goes back to what I was saying just before, is that the court determined that the lower court had struck the proper balance. In other words, that the balance adequately protected the due process rights. And part of that—
In this case, counsel was, if I'm not mistaken, counsel was requesting that the prospective jurors totally remove their masks during the questioning.
He was talking specifically about the jurors being questioned. She was actually talking about the jurors specifically being questioned, said either remove the masks or, as an alternative, provide them with clear plastic shields.
Right, and so Supreme Court, the trial judge stated, no, I'm not going to do that because of what's going on with the pandemic and because of concerns with the health of the other jurors, court officers, et cetera, in terms of the fact that, there is, he stated that there was a, pandemic, it's easily transmittable, et cetera. So why did he not, why under those circumstances are you stating that the proper balance was not struck?
Because the court, in our case, wrongly allowed the safety considerations to trump the defendant's established right to see fully the faces of the questioned jurors.
What case really holds that?
I mean, well, the
And no case
anti-market,
really holds that. I mean, that's your argument.
yes.
And then going back to what the points being made, even with the mask on, a person's expressions can be seen, right, through their eyes, et cetera, et cetera.
So we're only talking about the covering, my understanding, the nose and the mouth.
Right.
You're hearing what the person has to state. So you're just not seeing the lips move, but you're still seeing the eyes. You're still hearing the inflection in the voice. You're still observing the body language.
From its first sentence, the Ramirez court is not questioning, the Court of Appeals in Ramirez is not questioning that the core of the anti-marky right and the more expanded protections under New York law, by the way, so all this federal stuff in the case is, but for all practical purposes, irrelevant. But there was really no dispute in the Court of Appeals that the anti-marky right ordinarily covers the defendant's right to fully see the face. There's really no dispute about that. It's whether this restriction given COVID, this restriction on the right to see fully the faces of the non-question jurors violates the defendant's right. There's really no dispute. And the court broadly and very strongly reaffirmed that the core of the anti-marky right is to fully see the jurors' faces to assess, and that includes the mouth, the face is part of the mouth, to assess whether
But you're stating that all of the prospective jurors, that other than all of the prospective jurors should have had their masks removed and/or plastered?
No, only the jurors who were being actively questioned.
So the jurors in the box, all the jurors in the box who are sitting next to each other, they should not have been masked.
No, only when, I'm sorry if I'm not being clear, only if questions are being asked of that individual juror.
So once the question is being asked of that individual juror, then the mask should be removed so that their mouth is visible to the defendant.
Yes, exactly. That vindicates the defendant's rights, constitutional right under state due process and statutory rights to fully assess the responses of the juror being questioned.
So a defendant would actually have to see the mouth, the full face of a juror in order to assess their credibility.
Yes, and that is strongly telegraphed by Ramirez itself, which in approving the bounce that was struck by the lower court, specifically noted that the defendant here was able to see the mouths of the jurors who were being individually questioned. And
But Ramirez does not state that had the defendant not been able to see the mouth, then therefore that would have been a violation.
Agreed. Ramirez doesn't directly say that, but that is what the court strongly telegraphed in reafirming the rights.
Strongly telegraphed to you.
Strongly telegraphed.
Because it didn't strongly telegraph that to me, but that's okay. We'll hear from your friend.
Yes, perhaps on.
You did, yeah, most definitely.
Good afternoon, Maria Wager for respondent. May it please the court. The masked voir dire did not violate defendant's rights to effectively participate in jury selection here. There is no case, as Your Honor asked, there is no case that I am aware of that stands for the proposition.
But in all honesty, we all experienced COVID, and with masks, not seeing the face, you can't see smirks, you can't see smiles. It does hamper to some extent, right, the ability to assess a potential juror.
Of course, Your Honor. I am not going to say that this was ideal or perfect in any way. But the question before this court is, did defendant's right to effectively participate in jury selection, not whether it was hampered, but whether he was denied that right. And here the court struck a balance between the safety and health of everybody involved in the process with defendant's right. And that right doesn't stand alone. There's other rights. There's the right to a speedy trial for that defendant and all other defendants. So the court here, the courts were at a standstill. So what the court did was balance defendant's rights together with the health and safety. And he was able to be present, and he was able to, as the statute requires, be able to effectively observe the demeanor of jurors, which includes facial expressions.
But why not a mask? Wouldn't the mask have actually been better or given the defendant and counsel more with respect to who they were going to select as jurors?
The plastic.
The face shield?
The face shield. And that's a face shield as opposed to a mask, right?
Correct. The reason that the court did not allow that would be to horse the record. I don't know if it was this health and safety
Well, I'm
protocol.
talking about the balancing. Wouldn't that be a more appropriate balancing of having a shield, as we saw people on the subways with shields, as opposed to a mask?
The reason I can't answer that is because the balancing goes to the health and safety and welfare, and it would depend on what the health protocol was at that time. And what I can glean from the record, it seems as if it was leaning towards face shields were not as effective as masks. And in fact, the defense attorney agreed with that during the trial. But I would like to point out that Ramirez, as Your Honor asked before, did not say that was the minimum that would pass constitutional and statutory muster, the face shields. They did not say that. And in fact, if they were telegraphing anything, they were telegraphing that masks or do strike that balance. What they said about masks was that at most, a slight restriction and permissible. And they did not limit that language to when the juror is not speaking, when that juror is not being questioned. They did not limit that at all. And I would also like to point out that at the time of Ramirez, the court administration's mandate was not in effect.
Well, Ramirez was like in, I think, 2022?
I don't have the dates in front of me. I do have it in the brief. It was months before the mandate, and this trial was months after the mandate. My adversary said that there was a directive at the time of Ramirez, and she
Ramirez,
cites-
well, okay, well, Ramirez was decided in 2024. This trial took place in the middle of the pandemic, right?
Right, it was during the pandemic, but it was before the mandate. What was in effect at the time of Ramirez was a governor's executive order that said a person shall cover in public place when unable or not maintaining social distance. So it has that loophole, if you will. The court order did not have that loophole. And in this trial, prospective jurors were socially distanced. If you look at the record, they're sitting far apart, they're using the whole courtroom, and they're actually using other rooms and had a TV screen.
Counsel, do you want to address the juror issue because your
I do, Your
adversary
Honor,
will
thank you.
address that. And particularly in light of the Chodakowski case, which your adversary relies heavily on.
In light of what case?
Chodakowski, which basically said that the ethnic animus was a significant motivating factor in a juror's vote or conduct. But do we have something like that here in this particular case?
We do not. A status as a victim does not automatically disqualify a juror. And I would point out that the fact that my adversary can point to cases where a trial court ordered a hearing does not mean one is required.
But I mean, if you're selecting a jury and someone says that they've been the victim of a crime and they can't be impartial because of how they felt about that crime, they would be removed for cause, right?
If they said that, the jurors here, while they allegedly, and I will say we're not conceding that this was actually said, and if it was said that it was true, but these jurors said they could be fair and impartial when questioned during voir dire. So they never said.
Because the juror did state that they had been the victim of a crime. Wasn't that it, that they allegedly withheld that information? Or at least one allegedly withheld that information?
That was the allegation, that they withheld that information, but they never said they otherwise could not be fair and impartial. But as this court has held, there is no legal authority that stands for the proposition that a hearing should be held to inquire whether a juror gave a truthful answer on voir dire, where the only evidence to justify that is the affidavit of another juror. And that's what you have here, is one juror's affidavit claiming this was said. So we don't know whether it was said, if it was said, whether it was true, because it appears that she was the holdout in a case with extremely overwhelming evidence. So what happened in that deliberation room, and the reason for the rule not to assail jury verdicts on this type of things is because it would be hard-pressed to find a verdict that could not be assailed based on just a juror's affidavit of something that was said during deliberations.
Thank you.
Thank you.
I'll get to the jury misconduct point. I just want to make the point that the face shields would have absolutely been the solution here. In fact, this court employed face shields at other points in the trial, so at least in the court's
So
mind.
at the time of this voir dire, what was the OCA guidance or
The
administration?
OCA guide, it was the mask mandate. It didn't say anything of whether face shields were okay or not. It said there
Well, there was
needed
a mandate for masks, so is that something that we should take into consideration?
Well, there was also a mask mandate at the time of the Ramirez trial, and yet the Ramirez,
OCA mandate?
it was Governor Cuomo's mask mandate statewide. In any public place, you had to be masked. So I don't think, so there were safety considerations that the court was weighing in Ramirez and approved the balance that the trial court had struck, which included allowing the jurors to fully see the faces of the question jurors, and there were safety considerations here, and the due process balance was set by Ramirez. But I'll go on to the juror misconduct claim. The juror misconduct claim here checked every box of CPL section 330.30 sub 2. First, there was a legal basis for the claim, which was that these two jurors concealed information during voir dire. It is not true, it is not supported by law, that there are only these artificial categories of what misconduct is. Concealing information during voir dire is a cognizable claim recognized by the Court of Appeals in Rodriguez, recognized long ago by the Court of Appeals in Winship. Both cases are
Well, we
cited
don't
in
know
our
that,
briefs.
that two concealed. We know that one states that he or she concealed and states that another juror
Yes,
also concealed.
potentially concealed. And the affidavit of Ms. Roy was absolutely, again, sufficient under 330.42, which sets out what the requirement is to support a cognizable claim. And it says the sworn allegations based on the personal knowledge of the affiant. That's what it says.
So did she say in her affidavit that she was not fair and impartial and that she did not go along with the verdict, the guilty verdict, the conviction?
Her affidavit included a lot, much of which we are not pursuing on appeal. The salient point that's relevant for these purposes and the claim that we are pursuing is that she, from her personal knowledge of being in that room, heard these two jurors say that they had both been crime victims when they had not disclosed that during.
And so, and the fact that they were victims of a crime, did they also state that because of that experience, they could not and were not fair and impartial in this particular case?
They might have said that if they had been asked about it on voir dire.
No, I'm asking in terms of the affidavit, because there are times where I've encountered, and many of us have encountered during voir dire, where a juror states, yes, I've been the victim of a crime, my whole family, everyone in my family has been the victim of a crime, but yet and still I can be fair and impartial.
Right, it's possible that had they disclosed that during voir dire, the defense counsel would have been assured of their.
But my point is, was there sufficient information or allegations in the affidavit which would therefore lead the judge to grant a hearing?
Oh, yes, absolutely, because the substantial misconduct here, which was the failure to disclose, may have, which is all the statute requires, may have, the misconduct may have affected a substantial right of the defendant, which is his right to a jury in which he has a voice through full and fair selection, where defense counsel can probe these claims. We need the hearing to determine whether that may ripens into, yes, the defendant was prejudiced.
Don't we need the affidavit to specifically state that because they were the victim of a crime, they were not fair and impartial, could not have been fair and impartial?
I'm not aware of a prerequisite where the affidavit needs to do more than attest that juror misconduct potentially occurred. That is here concealment of information during voir dire that may have prejudiced the defendant.
Thank
That
you.
satisfies 330.30. Thank you.
Thank you both. Ansbro v. Negro.
May it please the court, my name is Brian Shute. I represent the petition of firefighters. Our position here really boils down to two basic points. One, while no employee has a statutory right to a reasonable accommodation, every employee has a right to, as this court put it, as the Court of Appeals put it in Jacobson, a collective dialogue that is individualized.
Right, but the cooperative dialogue, haven't we basically held in many cases, counsel, that it's sort of baked into the process, so that there's this process for considering either religious or health exemptions, and that I thought that we found in many cases that that is okay, that process provides for cooperative dialogue. And also, I mean, we definitely, our Court of Appeals held in Marsteller, which I was surprised you didn't grapple with in your initial brief, because it came out before your initial brief. But isn't Marsteller at least, doesn't that block this claim?
Let's start there then with the case law, and then I'll go to the facts of this case and why it's different. This court has, to the best of my knowledge, had 6 cases like this. Your Honor, everyone on this panel has been on 1 case like this. Your Honor has been on 3 cases like this with Department of Health.
And I think I was on Marsteller.
You were on Marsteller. None of these cases said or suggested that because COVID was an emergency, the employees lost their rights. All of these cases looked at the facts of the case and found reasons why it was rational and not improper to deny the accommodation in that case. Marstetter, we'll start there. Marstetter, this court said, I'm quoting, "The petitioner's application contained a generic statement that does not support this request, and it failed to explain how his religious tenets conflict with the vaccine consequences." That was an NYPD case. In the second NYPD case this court had 2 months ago, the court gave the same 2 factors, and a third one, that the application was based upon false information and misinformation. In the 4 Board of Education cases, Bryan, Lynch, Hogue, Leibowitz, of which all of the rest of you were on at least once, and you're on it 3 times. Apart from emphasizing that the Board of Education had shown that if they were working remotely, if the teachers were working remotely, they couldn't perform the core functions of a teacher. Apart from that, the Leibowitz case that the failed to establish how the tenants or why the tenants precluded use of the vaccine. The Hogue case, the body of petitioner's initial application appeared to be entirely copied from an online sample application. And also, there was no showing of sincerely held religious beliefs. And the Lynch and the Bryan cases, again, the Bryan case specifically mentioned, that was Justice Rosado as well, didn't establish that the request for accommodation was
So a couple of things. In all of these, in the majority of cases, I remember Lynch, Marsteller, I forget the other ones, leave was denied by the Court of Appeals. And in all of these cases, what we dealt with was the procedure, whether or not the procedure enacted by the city, was proper.
Well, in all of those cases, the court looked at the individual facts also and determined whether this particular determination was arbitrary or capricious.
Right, because you started out your argument by stating that the employees were giving up their rights.
No, I started out by saying that no employee, while no employee is entitled a statutory right to an accommodation, every employee has a right to a collective dialogue.
Exactly, and so, right, so, but in all of these cases, the question was whether or not the procedure in place was proper, whether it took into consideration the rights of the employees as well.
Can I get to the procedure in this case, Your Honor, and the facts of this case? By way of context, pages 17 to 18 of the record, the EEOC guidelines. Generally, under Title VII, an employer should proceed on the assumption that a request for religious accommodation is based on sincerely held beliefs, and it goes on to say that if the employer has reason to suspect not, the employer can conduct a limited factual inquiry. In this case, the FDNY demanded, in order for the application to be complete, that the applicant include a attestation from a religious or spiritual leader stating that the member was in good standing and that and known to the leader, and also that the tenants forbid the use of the vaccine. Now, here's what this man, Daniel Richter's application showed. Everything I'm about to say is from pages 54 to 57 of the record. It's right in his application. Apart from stating that he accepted Jesus Christ as his Lord and Savior at age 14, that he researched and found that the Pfizer, Moderna, and Johnson & Johnson vaccines were all developed, tested, or generated using the cells of an aborted baby. And, quote, to use the cells of an aborted baby in this way would be equal to child sacrifice that he would never, ever participate in because it would be a sin against God, citing Genesis, 1 Corinthians, and Romans, passages there. Was it sincere, his belief? He had served as the missions ministry director for the Powerhouse Christian Church. He had gone to northern Uganda on a ministry to devote his time at a medical clinic, Bible schools, digging wells, and where he also gave his first sermon. He devoted his time after the earthquake in Haiti.
I don't think we need to doubt his sincerity, for sure, counsel. You're right. However, should he also have excluded other, that he's never taken a vaccine that used the stem cells that he was alleging were used in the COVID-19 vaccines? You have to also say that? I mean,
he said he had
to be consistent.
He said in his materials that he had general objection to all vaccines for the same reason he didn't take alcohol and meat, but he had a particular objection to this vaccine because of the use of aborted cells.
Right, so, but the question is, were there other vaccines which he did accept, which also used stem cells? Did he also make use of those vaccines?
Well, he hadn't taken any vaccines.
No, he's never been.
He
was never
think that
vaccinated for
as a
anything in his life.
He said, I can't say that based
No, I'm not. What I'm saying, was there anything in his affidavit or his letter, et cetera, which stated that, and would that not have been somewhat necessary or relevant?
That he was against vaccines. He didn't say or make an uncategorical statement that he had never had a vaccine in his life.
And then there was another petitioner with Epstein-Barr, right? I'm sorry, Guillain-Barr syndrome, right? And he was told never to get a flu or COVID vaccine.
Yes, if I could just stay with Richter for one moment more, Your Honor. He had also turned down a promotion to lieutenant. This is right at the same page as I mentioned, because it would interfere with his ministry work, more specifically his work in feeding families at the local ministry and his work with developmentally challenged children and adults. This was how serious he was. And he did have that letter from the lead pastor of his church at pages 56 to 57, who specifically said he cannot, firefighter Richter, cannot take this vaccine with a clear conscience. This stems from his deeply held Christian conviction that abortion is wrong in all circumstances and that the use of the cells of an aborted baby to generate a vaccine would be equivalent to the ancient practice of child sacrifice that God called an abomination, citing Romans 14:23 and Leviticus 22. The denial of this was, you can see this at page 49 of the record. The basis for accommodation was insufficient to grant the requested.
And what was the accommodation?
I'm sorry?
What was the accommodation?
To where he wanted to weekly testing, to submit to weekly testing rather than to take the vaccine. Kevin Martinez.
Well, we're not going to go through all of these right now. You have time on rebuttal. Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the court, Philip Young on behalf of the city. I want to make a very important preliminary point here. The issue of whether the city's determination denying these reasonable accommodation requests was arbitrary and capricious is not at issue in this appeal. The only merits argument that the appellants raised in this appeal is the question of the cooperative dialogue issue.
Right, and that's what I stated. In all of the cases, we found that was present, that there was, that the procedures were followed, and that the procedures were met and the cooperative dialogue was met as well.
Exactly, Your Honor. Marsteller, Lee, Lynch, Leibowitz, Hogue, all of these cases, every one of them follows Marsteller. They apply Marsteller's test and they say the city's process for employees to apply for reasonable accommodations complies with the requirement.
The plaintiffs argue that the NYPD's denials in Marsteller of accommodations were more detailed and therefore reflected more of a cooperative dialogue because they got into the weeds a little bit more than the denials in this case. You want to respond to that?
Sure, Your Honor. I don't think there's any real substantive difference in the detail of the dialogue that happened with NYPD versus DOE versus FDNY. All of these agencies were following DCAS's guidance, and they were using the same procedures to evaluate these reasonable accommodation requests. In this case, the FDNY provided a reason for the denial. It was undue hardship to the department. They provided supplemental letters providing additional information.
Did you, with more details that was submitted?
Yes, more. The FDNY provided a supplemental letter a few weeks later that provided additional information about the undue hardship basis. And again, I want to emphasize that in Marsteller, the issue of whether the city's procedures were consistent with the cooperative dialogue requirement in the city human rights law did not depend on the level of detail that the agency went into in its decision denying the reasonable accommodation request. What this court said in Marsteller is, does the city publicly offer public information on its process for reviewing reasonable accommodation requests? Yes. Does the city inform employees how to apply to their agency's EEO office and how to appeal the denial? Yes. Does the agency explain why the applicant didn't qualify? Yes. Did the parties engage further during this administrative appeal process? Yes.
Counsel, just to clarify one thing, you're okay, I take it from your briefs, to not bother with the procedural mess that happened at the trial level, right? We're going to the merits in this case, correct?
That's correct, Your Honor. You should go straight to the merits. And then finally, I just want to briefly note the case that appellants raised in their reply brief. I believe it's Friedman v. Bloomberg. That case is far afield from what we have here. I would analogize it to Hosking, which is the case that this court distinguished in Marsteller, where it's a summary judgment plenary action, and the court found that there were tribal issues of fact about whether the employer in that case even bothered at all to consider an accommodation request. That's very different from what we have here, where the city established a thorough, detailed, and comprehensive procedure for evaluating these reasonable accommodation requests, followed that procedure across all of its city agencies, and this court over and over again, Marsteller, Leibowitz,
But what I'm
Lynch.
hearing from your adversary is that essentially it's a rubber stamp response. I mean, not a meaningful response in any way. What's your position on that? It's sufficient just to give a conclusory response?
It's certainly not a rubber stamp, Your Honor. I mean, I think in this case, there's evidence from the FDNY's affidavit that the FDNY, as of, I think it was January 2022, which is early on in the process, granted dozens of accommodation requests.
I remember in the other cases that we had, there was some discussion and some statistics as to the number of applications that were received and the number of applications that were granted.
I don't have those statistics off the top of my head. I know the number of applications received is in the thousands. In Marsteller, it was
2,000, right?
So in Marsteller,
2,000 religious and medical accommodation requests.
There's probably even more than that
From
citywide.
FDNY.
Yeah, FDNY, that may be right.
Right.
NYPD, there were 6,000. There were much more from DOE. So, I mean, the whole point of Marsteller was this court acknowledged the unique circumstances of the COVID-19 pandemic, the need to resolve thousands and thousands of accommodation requests in a constrained timeline, in a public health emergency.
But as my colleague just stated, you know, as your friend said, he went through in terms, I think it was Richter, in terms of letters from his pastor, his turning down a promotion, et cetera. It seems as if he went through a number of issues as to a number of factors as to why he should not have to take the COVID vaccine.
Again, Your Honor, that the question of whether the FDNY's denial was arbitrary and capricious is not at issue in this appeal. The only question is, did the city's procedures satisfy the cooperative dialogue argument? These arguments he's making before you were not raised in his opening brief or in his reply brief.
Thank you.
Thank you.
Very quickly. The only communications regarding the first gentleman I mentioned, Richter, explaining why he was denied is the form denial that it was insufficient.
Well, did you wish to respond to his last statement that this was not raised by you?
It is, of course, is raised in the petition, and the city in their brief says this should have been decided on the basis of the petition and the answer and nothing else. Your Honor asked about...
Many of the cases cited by the respondent involve them submitting an affidavit to the court with greater detail as to what went into the decision. That didn't happen here?
No, I don't know why they denied Richter, except for the fact he does not meet criteria, and except for the fact it was insufficient. Not enough pastors, not enough Bible sites, not enough turned down promotions, I don't know. With respect to Martinez, it's even clearer that this was just a rubber stamp. Your Honor mentioned him. He was diagnosed at age 3 as having Guillain-Barré syndrome. His legs were locked in a fetal position. He couldn't walk. It was only through treatment that he eventually regained the ability to walk. His treating doctor said, and I'm quoting, "Patient is at serious risk of the recurrence of this life-threatening illness if he receives the COVID vaccination." That's at page 68 of the record. That opinion, Your Honors, was actually superfluous. Why was it superfluous? Because the FDNY itself said it was a contraindication to taking COVID. This is from page 62 of the record, from their own Bureau of Health. It is not recommended that you get vaccinated if you ever had a severe allergic reaction to the vaccine or suffered from Guillain-Barré syndrome. So, what happens? He submits this to them, and he gets word for word the same denial that Richter got for his religious request. And this you'll see at page, word for word, page 63 of the record. And then word for word, the same rubber stamp from the accommodation panel. It does not meet criteria, those same 4 words. How is that not, how can you, and does not meet that criteria? Insufficient? How could it be insufficient? Fatal's not good enough? Or maybe it wasn't a high enough risk?
The other part of the criteria is, of course, not only the individual's rights, but the rights of the workforce as well, and the rights of the public. So criteria also, right, include health of the public and health of firefighters who work in close quarters.
I'm glad you mentioned that, Your Honor. You will find in the record that he expressly agreed to weekly COVID testing, which some might say is actually better than the vaccination. You can get COVID after being vaccinated, and also being masked. But more than that, Your Honor, this is from the petition, and it's actually Exhibit B to the petition. This reasoning about there was an undue burden. Quoting from a fire department document, 4 requests filed after October 27, 2021. The only allowable accommodation from vaccination without causing undue hardship and/or disruption is submission of a weekly negative test result. Then the man with Guillain-Barré syndrome offers to do exactly that, and he's denied because his application was insufficient and does not meet criteria.
Thank you. Thank you both. 1TESB 158 Management.
Good afternoon, Your Honors. May it please the Court, my name is Anthony York of Sowell Pevsner on behalf of the defendants' appellants. The lower court's decision should be reversed as a matter of law because they incorrectly applied the doctrine of res ipsa Locator, as
Well, let's talk about that.
How often does a sidewalk collapse? I'm just wondering, if a sidewalk collapsed, don't you have to figure that there's something going on there?
and Your Honor, I completely agree. I think that that is
Where the woman, where the plaintiff is just standing there, she's standing, not doing anything, and all of a sudden, the sidewalk collapses under her. I don't know how much she weighed, but I don't think that she weighed
it
a
was
sufficient
fairly
amount.
slight, to be honest. But that's one of the factors of res ipsa locator.
Okay, so what factors are you saying?
The one that we think that there's questions of fact are the exclusive control. The record is.
And you
has
represent who?
The management,
What-
Okay.
150, the building owners.
The where the plaintiff fell was atop a cellar.
It was on top of a cellar that
The cellar vault, right?
cellar vault that the management never knew about until the day of the.
But it was in your building.
It was there was an entrance into the basement of the building.
But he knew how to get to the building.
Rodriguez, I thought the superintendent's name was Rodriguez, right?
Mr. Rodriguez,
And he
correct.
knew how to get
He
to it
saw
and
plaintiff
direct the
when she fell, and then he went down to the basement. And that doesn't. But he
Was that
did
the first?
testify.
You're saying that that's the first time? Oh my goodness, there must be a cellar.
They
a cellar
both
vault
testified
down
that they were
there?
never
And we happen
aware.
to have the key to open the locked door.
The deed was silent as to the inclusion of the cellar.
But so he's never been in the basement, so therefore he's never seen the cellar or that there was a cellar vault?
He's testified the first time he became aware was when he saw Ms. Fuentes in the vault. The manager, who's the brother of the owner, testified that he was unaware that this vault existed.
Okay, but still, how did
he know how to get down there? How did he know how to get down there?
At that point, I mean, he just saw her and he went into the basement and saw.
How did he know to get down there through the basement?
I mean, he was just trying to. I cannot,
Yeah.
Okay, but even so, how does that relieve you of any liability, or at least issues as to your liability, where it's clear that the cellar vault is under your property?
I think that the record relied on the affidavit from the city saying that in most cases, private property seller is owned by the private property owner, and then if it's a city entity vault, then there usually is.
Okay, but even if we disregard the city's affidavit, how did you put in anything, or have you made any showing that anyone had any control of that cellar vault other than the building owner?
We did not put in anything to that nature, but it's on this. They have to prove, there's no material issues of fact. It's
But don't
their
you
burden
also have to put in something to show contrary how others would have access to that cellar vault as well, that you had no knowledge of until she fell into the cellar vault?
We believe that there's issues of fact as to there's circumstantial evidence. A jury may, very much.
Who else would have control over the cellar vault other than you?
It's possible city entities.
How would the city, when the city had no access to that cellar vault?
I mean, it's unclear. There's nothing in the record to establish one way or the other. It's just circumstantial that because.
Well, wait a minute.
Yeah.
Wouldn't you have done an inspection and attempted to show that in fact there may be another way to access the cellar and therefore the city has some control?
There was an inspection done and there was only one door.
And where was that door?
It led from the basement of the building.
So doesn't that suggest, at least prima facie, that
I agree that the evidence may suggest one way or the other. I think
prima facie that in fact you had exclusive control, then it's up to you to raise issues of fact as to that, right? And how did you do that?
I would say that the fact that the management, when they bought the building, they were never made aware. The deed is silent as to the inclusion of the vault. There's no mention of the
Somebody
vault.
had a key. I thought also Mr. Rodriguez had a key so that he was able to go into the basement and also and the cellar vault.
He was able to enter the cellar.
And just to be clear, this building, because based upon the employment of some of the individuals who testified, predates like 2010, the ownership of the building, right?
Correct.
And inside the cellar vault, where in the wall, which like kind of led up to the opening, there was I just thought this very interesting, a potato chip bag that was expired years before this particular accident.
No, I believe during an inspection of the attorneys and the expert, they found a potato bag that was dated 2010. The building was purchased 2009. That's not to say that the building manager was aware of it. It could have been a tenant. It could have been a child down there. that doesn't signify one way or the other that
A
building.
tenant or the child who would have access to the cellar, but not the building owner?
And right, who would have a key? Because again, my understanding was that it was locked. Yes, a locked basement door.
It was closed, Your Honor.
Okay.
I rest.
I thought it was locked. I thought you needed a key, but thank you.
Good afternoon, Your Honors. May it please the court. My name is Pasha Rubin from Stephen Adam Rubin and Associates, and I'm representing plaintiff respondent Mariana Fuentes, who was just standing on
Okay,
the sidewalk. Yep.
Can you get to the point that your adversary is making?
Yes.
With respect to exclusive control?
Yes.
And my colleague here is suggesting that there was a key to a locked door on that vault.
So-
What's your view of that?
So first, I would like to backtrack a little bit, if that's all right. Counsel mentioned that the deed was silent as to the existence of the cellar vault. There was a prior decision on the motion to dismiss by Justice Love, I believe, that said that deeds do not address what is beneath the ground. So saying that the deed did not have the underground vault on it is actually misleading. The deed would never address the existence of a cellar vault in the first place. Second of all, I'm hearing different things. Before it was a wall, and then it was a locked door. The fact of the matter is that
How is it shown that they had exclusive control?
so the reason why they had exclusive control is that this cellar vault is connected to the basement, where the sole access is from their building. The Department of Buildings inspector who inspected immediately after the accident, Mr. Frank Cosimano, he inspected it and said that there was only access through the building.
Through the basement.
Through the basement, correct.
Was there a locked door?
There was no locked door. I mean,
Was there a door?
access. I'm sorry.
Was there a door?
There was no door. It was like an alcove, really, and
You're saying there's essentially an opening.
exactly, and so and furthermore, Alex Rodriguez, when testifying that he was able to lead the emergency personnel through the tunnels of the basement in order to bring them to Ms. Fuentes, he further testified that no wall crumbled, that was blocking them from Ms. Fuentes, and that there was additionally no need for the fire department to break down any walls. The opening was right there. They were able to access her, so there was no question as to that. Additionally, as Your Honor mentioned, there was a bag of chips that was found with the distribution date of 2010, and the purchase of the building was in 2009.
Yeah, but if what your adversary says is, and you acknowledge if there was just an alcove, it could have been a kid, it could have been anyone who could have gone in with a bag of chips, right?
Sure, but that would still render the cellar vault within the exclusive control, and it would trump the entire argument that they've been putting forth that they had no idea that this cellar vault existed, when in fact, if a child is able to access it, then management should be able to access it too and inspect the corroding beams from beneath. Furthermore, I would like to add that it is not just the cellar vault where there were the corroding beams, where Mr. Frank Cosimano, as well as the expert engineer, all observed the debris after the accident, but even when we did the site visit, the beams were starting to degrade already. But there are photos of the sidewalk where you see cracking and backward sloping, and our expert engineer did testify to the fact that this is a telltale sign of water ponding and water damage, which corroborates the corroding beams, which should have put a reasonable owner on notice that something was wrong and that they should immediately inspect it.
Thank you.
Thank you.
Your Honors, may it please the court, my name is Amanda Abata and I represent the city respondents. With regards to what we've been mostly discussing here, the ownership and occupancy, exclusive control over the cellar vault, what's clear is that the city did not have ownership and or control over the cellar vault. The imposition of liability here is obviously predicated on this occupancy, ownership, control, or special usage, and that doesn't apply here. The record shows that the cellar vault was privately owned by 158 Management, and the city had no access to it. The Frank Casamano's affidavit outlines that in his 2 building inspections, he noted, obviously, like we've discussed, that the sole entry and exit points to the cellar were through the building basement. And as an aside, I would like to sort of note that I believe it's the same building basement that Mr. Rodriguez lived in. So the fact that the super lives in the same basement as the cellar vault, to say that he wasn't aware of it obviously doesn't seem supported by the record.
Now, sometimes there are vaults, my understanding that there are vaults that protrude out, and then there's access to the street from the vault. And if there's access to the street from the vault, then the city would have some control over it. Is that
Yes,
correct?
there were those instances, but obviously that wasn't the case.
So there's no access to the street from this cellar vault, right?
No, Your Honor. The vault reinforcements also that were made were not in accordance with the city standards nor with the standards of the contractors that the city utilized. And as we've discussed, Alex Rodriguez, the building super, corroborated Casamano's findings, testifying that he took the emergency personnel through this to the cellar, through the basement to the cellar entrance to locate Fuentes, and testifying that that basement door was the only way to get to Fuentes in the cellar. So, Your Honor, if there are no other questions, and obviously the city also had no duty with regards to the sidewalk, as under the sidewalk law, the property manager had the responsibility of maintaining and rectifying any sidewalk defects.
Thank you.
Waive rebuttal.
Oh, thank you. Hope there's nothing we said. Stern Club v. Davis.
May I start? Natalia Gurari, may it please the court. I represent Marvin Davis, the defendant herein and the appellant. We submit this decision below should be reversed for the following reasons. First, the court overlooked that there was an oral stipulation that was incorporated into the judgment of divorce that clarified the terms in paragraph 10 of the stipulation.
Is there an ambiguity in paragraph 10 with respect to whether the kids get 12.5% or 25%?
Your Honor, it appears there is an ambiguity since the judge read it that way.
I'm asking you.
I do not believe there is ambiguity at least as far as the part of that paragraph where it says that the sum of $660,000 has to be divided in equal shares between the children. To me, if you divide a single sum of $660,000, if you divide it in equal shares, that means each child gets $330,000. The judge actually did judicial modification of the clause and added the word each in order to fit it to her construction. As a result,
that paragraph, does it use the word divided?
No, it says...
the issue really here is how do we interpret the phrase in both children in equal shares, right? Does that mean both children receiving equal shares? Does it mean each child receiving an equal share? And or should it say those two things that I said, the latter, if that's in fact what it meant?
Your Honor, I agree with you that it is ambiguous. It could be ambiguous because...
Well, if you agree it's ambiguous, then shouldn't there be some kind of hearing or something?
Yes, and the judge denied the hearing. The judge decided it's unambiguous.
So what is your position? Is your position that it is ambiguous and therefore there should be a hearing, or is it your position that it is not ambiguous?
My position is the way it ended up being written in the stipulation, it could be read in two ways, just because I could see that two different.
So you're conceding the ambiguity, so then the hearing should have been ordered?
Yes, but there is another
Yes,
document.
you are conceding the ambiguity?
I'm conceding the ambiguity, but there is another document which is part of the judgment, another oral stipulation that specifically clarifies that everybody ignored.
So let me just see if I understand. There was a oral stipulation that was reduced to writing?
Yeah, yes. It is an oral stipulation that was reduced to writing. It was an allocution, and this is record number 20, page 2021 of the record, which
Counsel,
was.
I don't know if, are you arguing?
Yes.
Never mind.
Yes, so it was submitted on a motion to renew. It was referenced in the judgment that was before Judge Dreger, but on the motion to renew, it was submitted in full. The allocution was submitted, and page 21, record page 21, counsel actually put it on the record that the way they interpret the stipulation is should be $660,000 in trust for the children. So
when you say counsel, you mean?
Well, for the counsel for the wife, for the plaintiff.
So I'm confused what your position is as we sit here. Is your
Yes.
position that there should be a hearing on the ambiguity, or is your position that this provision is clear and unambiguous as a matter of law?
My position is that the way it is written in the written stipulation, it could be the second part, the second option, which is a quarter of the house to the children, could be read in two ways.
So then what do we do with that if we have this oral stipulation that maybe can imply one thing, and then we have this written stipulation that you're conceding can be implied two different ways? Where do we go from there with that?
Well, the court is permitted. There is precedent that I cited. The
But
court
where do we
is-
go? So
What
you
relief
wanna-
are you asking us?
Yeah.
I'm asking you to do one of two things: either remand it to the lower court for a hearing
On what?
on the ambiguity of the clause, whether the
Or?
or use the oral stipulation, which is part of the same judgment, which clearly, the oral stipulation clearly explains what is meant in the written stipulation. So this court can look at the oral stipulation to.
So you're conceding that it is ambiguous, but you're stating that the oral stipulation clears up any ambiguity.
Yes, that is exactly my position. That is exactly my position. I mean, when I was, drafting the stipulation, I didn't read it the other way. But after I read it only the way.
So your adversary convinced you that you
No,
were
my
wrong.
adversary did not convince me. But the fact that the judge read it in some other way that.
So as opposed to appealing, stating that the judge was incorrect, you're going to accept her statements and just say, oops, I made a mistake. But if you look at the oral stipulation, then it clears up any ambiguity.
May I correct, you want to correct myself. So my position is that this should be read, $660,000 in equal shares should be read as $330,000 to each child.
Is there any
Yes.
ambiguity in the stipulation with respect to that?
When I read it, I do not see an ambiguity.
So is it your position now that there is no ambiguity?
My position is that there is no ambiguity, but there is an oral stipulation that, to the extent there is anybody think of reading it another way, the oral stipulation makes it clear.
Counsel, inside the stipulation, and if you could just direct me to the page reference where it says that the oral colloquy is incorporated by reference into this stipulation.
Yes, record 119, 119 that was actually before both judges, says that the oral stipulation is the ruling stipulation. That's what the judge says.
Is the ruling stipulation?
Yes, yes, if you read.
This was a determination by whom?
This is written in the judgment. The judgment of divorce says the court acknowledges the settlement reached by the parties and all issues were disposed of by oral stipulation of settlement placed upon the record, which is February, and it's the reference as February 27, 2019, which is record 14 to 21.
Thank you.
Yes.
May it please the court, Stephen Altman. I represent Sarah Sternklar.
Counsel, if you could just, in just picking up that thread with that your adversary just left, in terms of record 119, and then the stipulation that we have, the written stipulation that's incorporated but not merged into the judgment of divorce.
I'd be pleased to do that. In fact, I direct the court's attention to 3 separate provisions in the stipulation of settlement which preclude any oral modification. Record 110, paragraph 114 of the stipulation of settlement. Modification, amendment, and waiver. No provision of this agreement, I quote, no provision of this agreement shall be amended or modified unless by agreement in writing, duly subscribed and acknowledged with the same formality of the agreement. That's one. Record page 109, paragraph 111 of the stipulation of settlement. Merger. This agreement and its provisions merge any prior agreements of any of the parties and is the complete and entire agreement of the parties. 3. Record page 103, paragraph 93 of the stipulation of settlement. This agreement contains, this is a quote, this agreement contains the entire understanding of the parties with respect to their respective rights to receive dower, blah, 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 everything. It's the divorce settlement. So the concept that this could possibly, this written agreement that was negotiated, I was not trial counsel, I'm post-trial counsel.
So let's just go back to the settlement. Does the phrase "in equal shares," isn't it fair to say that the parties intended to divide the transfer of monies equally between the children, meaning $330,000 or 12.5%?
No, had they meant that, they would have said very simply, and that's what both Judge Drager and
What else can "in equal shares" mean?
what they were dividing. Let's take one step back to see what we're talking about. This was, these people have substantial assets. This is a small piece of one of them.
Maybe the tail of the dog.
50%. The wife owned 50% of the Bridgehampton house mansion, right? As part of the divorce agreement, she was giving up her 50%. Half to each of the children. That's what this is.
But it doesn't say that.
Well, but that is what
I
it
mean,
said.
it would have
In
been
equal shares.
helpful to your case if it said
Of
that.
course.
But what we do have that
Could it-
maybe
could
might
it-
be helpful to your
what it
case,
doesn't-
counsel, is the fact that the adversary is now actually conceding that there maybe should have been a hearing.
No, I don't think there should have been a hearing. I think the agreement is clear on its face.
But you're saying that all the merger clauses that you just cited point us to just looking at paragraph 10 on its lonesome, right?
Honest, that's
But
right.
that's what we have to do.
And if
And it says, convey to the children in equal shares.
equally, 660 to you, 660 to you, which makes sense.
But you're adding terms that,
No,
that,
I'm
that
not
don't
adding
exist
terms.
there.
Though that's what it says. Here's the problem. In order to, if you were to agree with the appellate that there are added terms, it would be adding terms to say each get 330 and each get half of a quarter. That would be adding terms, and that's in fact exactly what Judge Drager said that in her opinion. She said, "I'm not adding terms. In order to accept Mr. Davis's alleged interpretation of the agreement the way his counsel drafted it, I would have to add words in, which would say each get 330 and each get a quarter or half of a half. That's not in the agreement. The agreement says in equal shares, you get 660, you get a quarter. It makes sense. This couldn't be more simple. It's almost sort of mind-boggling, and for a father to be basically trying to steal a quarter.
That's another issue that I'm sure they'll have to work out. But to the children, not to each child.
I'll say this with respect to that, to quote some politician.
And they were both represented by counsel at the time.
They were. Could paragraph 10 been clearer? Always. I think any agreement that I agree. But the question before the court is it on its face clearly and unambiguously say what it says? Well, is there enough there? And other than these after the fact, forget about the merger clause, it doesn't matter.
It would seem to me, though, counsel, that you would want us to say that it's ambiguous and therefore there should be a hearing.
No, it's clear. I think Judge Strager was right. I mean, I argued this case before Judge Strager. She was screaming at us in chambers after the argument, sufficient for our clients to hear. That's how adamant and clear she understood. This is the case that she presided over, that this is what the settlement was, and that's what was happening.
Thank
I mean,
you.
that abhors the record, but that's what happened.
Thank you.
Judge Drager did not preside over this case. In fact, you'll see the transcript of allocution. It was Judge
So you
Juan.
drafted the stipulation?
No, the stipulation was actually drafted by Cohen Clare. I was, yes,
Well,
I was negotiating.
Your side drafted.
Correct,
Correct?
correct.
So if there's an ambiguity, and your side drafted it, wouldn't that ambiguity be held against your side?
I didn't draft it. It was drafted by Cohen Clare, which is top law firm that
Whose
represents
side, was the wife's side or the?
the wife's side. Cohen Clare, which is a top matrimonial law firm in,
You're
in
saying
the
it was the
city.
wife's side that drafted?
Yes, yes, and they put it on the record. They were allocated, and the wife's counsel specifically explained what it was. Moreover, if you look at the context of this stipulation, R65, second property, marital property is given 100% to the wife, which is why the husband was supposed to get the full second.
What about the merger clauses? What about the merger clauses? Your adversary referenced that the oral stipulation or the oral record part of it doesn't matter because we have these merger clauses that says that this written document is the final say.
Well, it's obviously a contradiction here. You have a judgment that references the oral stipulation as the main stipulation, and then you have a written stipulation. If you read the allocution, it says that in the allocution that we came with a written stipulation, but didn't negotiate final terms. So the oral stipulation was February 27, and then explain what the terms are going to be as far as the agreement, and then came with the written stipulation. It was done, it was messy. It did look messy, but the merger clause does not explain the substance of the problem. I mean, the clause to me, clearly says half of 660, and when you look at the context of the agreement, children are defined as two children. There is only one place where you have each child, which is in deduction, tax deduction part, and it's clearly separated. The top law firm drafted this, Cohen and Clare, and you could...
Top law firms make mistakes. Right?
Yes, okay, thank you.
Thank you both. Castro v. Brito. Yeah. Good luck.
We're going to talk.
May it please the court, Brenda Fitzpatrick, counsel for the appellants. Your Honors, I believe that the homeowner's exception to Labor Law Section 240 and 241 applies to Mr. Villavicencio.
How do we deal with the Fisher case out of the Fourth Department?
Two things. First, I think that the Fisher's decision suffers from the same rigidity that the Court of Appeals and the legislature said shouldn't be applied when considering the...
I mean, and also the cases that inside that Fourth Department decision, none of them really dealt with this particular kind of homeowner exception, right?
No.
So the Fourth Department came up with this rule based upon, they kind of extrapolated, things that dealt with like a utility company and things like that, and they brought it over here into this homeowner exception.
Yes, and I think, so when you look at the Fisher decision and what the Fourth Department did in that case, before I can even go into how it's distinguishable factually, you look at what the legislature was, the intent, specifically intent, the bill jacket specifically says that this amendment, this exception, was to cure the unrealistic, because it's unrealistic to expect an owner of a one or two family dwelling to realize, understand, and insure against...
The owner of a one or two family.
Yes.
So how is he the owner under 241 and 241-6?
And in Bar 2 and Canon.
I'm sorry?
In Bar 2 and Canon, the Court of Appeals said the courts should not apply a rigid interpretation of this provision.
In fact, it could be someone who has an interest in the property, right? And is your argument that a spouse living in this marital residence has an interest in the property?
Oh, I think so. I mean, according to what plaintiff wants to do, you could take the expansive view of what an owner is when you're dealing with, say, a fee owner, a subtenant.
So he paid portions of the mortgage, right?
Portions of, pretty much from what I can tell, all expenses for 20 years. They lived there, this was their marital.
You said pretty much from, well, again, it's in her name because she received this as a part of the settlement from her first marriage.
Yes.
But he pays in terms of the mortgage. How else does he have any type of legal or beneficial interest in the property?
I believe he testified, and so did she, and they both attested that he performs repairs. He pays for repairs. He pays for maintenance. This essentially was his home, except they didn't have the foresight back in 2000 to put him on the deed. So again, this was squarely in line with what the legislature intended and what the Court of Appeals in Bar 2 said. You should to reflexively and rigidly apply this provision this exception.
Is he on insurance policies, mortgages? Is there any other indicia to show other than paying maybe voluntarily?
Your Honor, I think that's outside the record. I actually know it, but I think it's outside the record, and I don't.
Well, he's not even on the mortgage, right? Is there a mortgage?
I don't know if the mortgage documents. I do not know if they were in here, and I don't believe he is on the mortgage. I know he paid for the mortgage.
But if it came down to, we're talking about this interest in property, and maybe at a later date, right? Say we were talking about equitable distribution. There can be mortgage improvements and things of that nature matter, and that gives that person that interest in the property at that point. But how do we apply that to this labor law?
Well,
see, and Fisher, ago, it is the Fourth Department, and we are the First Department. It states that it states specifically the term owner in 240 subsection 1 and 241 subsection 6 does not encompass a spousal relationship with the title holder because that relationship does not create the requisite legal or beneficial interest in the property for purposes of these sections. It goes on to talk about whether there's a lease and, their payments on a lease, et cetera. But it specifically states that that spousal relationship is not created for purposes of 240 subsection 1 and 241 subsection 6.
Your Honor, again, I think when you consider what the Fourth Department did in Fisher compared to what the Court of Appeals in Bar 2 said the court should do, and what the legislature put into the legislation, what the courts should do, they didn't follow it. They didn't follow it at all. And in addition to that, the facts in Fisher are far different than what we have here. We have a project that was probably a lot different than simply Mr.
But we still had a marital, there was still a spousal relationship in Fisher.
Yes, and the plaintiff, I believe Sandra Coughlin, actually called her husband her agent. So we don't have that here. Mr. Villavicencio wasn't he wasn't her agent. He was her husband. He is her husband. And she wasn't his principal. She's his wife. And that's the common realities.
And he's more than her spouse. He pays the mortgage, helps for the mortgage.
Yes.
Helps with construction.
Yes.
Brings in the people to do the construction.
Yes.
Takes them to buy materials.
Yes.
So he has an interest.
Yes.
But counsel, you're also talking specifically about the context of Labor Law 240 sub 1. Like if there was like a meets and bounds dispute with a neighbor, he couldn't be a party defendant in that case. It would have to be the title holder, right? It would have to be Ms. Brito, right?
Yes.
Okay, so it really is the specific context of 240 sub 1 that you're relying on here.
Yes.
An owner, that the definition of owner must be flexible, right?
Right, and I think in the context of home ownership, residential home ownership, we're not talking about Matt Calley, we're not talking about Tishman Speyer, we're not talking about commercial properties. We're talking about a home that he lived in for 20 years, that they raised their 2 kids, that he paid.
Which they never changed title to include his name on.
And this goes to what was written on the bill jacket. What you're doing is what plaintiff wishes to do and what the trial court did is you're treating Mr. Villavicencio like you're going to do Tishman. Even though the Court of Appeals said it's unrealistic to expect homeowners to have the foresight to cover for their insurance, to have to have the foresight for 20 years. We're living here. Do we need to change the deed?
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Daniel Murphy on behalf of the respondent. Just going straight to Fisher and the issue of the homeowner's exemption. When counsel asks for judicial flexibility or common sense, what he's really asking for is to set the statute aside, okay? The Fourth Department is not the only department to have dealt with this issue. There's not a whole lot of cases on it, but the second department had 2 cases from 2017, Rodriguez versus Mendlovitz and Abdul. And just like the quotation that was read from Fisher, they directly addressed the issue of a spouse of the deeded owner who is not themselves on the deed, and they state a spouse is not an owner for the purposes of 240 or 241.
But if you look to the legislative history and the goal of the homeowner's exception, would he not fit into that goal? Because he has lived there with his spouse for 20 whatever number of years. For all intents and purposes, he could be considered the homeowner, right? He is assisting in the payment of the mortgage. He is assisting in repairs to the premises.
I don't believe there's actually any evidence in the record that he ever paid the mortgage. My understanding is at the time of, at least certainly at the time of the deposition, there was no mortgage, and I don't believe there's been a mortgage on the property for quite some time. And I'm not sure that there was any testimony that he had ever contributed to the mortgage. Now,
Was there testimony that he contributed to the improvements of the home?
he did, but I mean, that wouldn't afford somebody a cognizable legal right to the property. Now,
In certain proceedings, not legal right to the property, but an interest in that property, right?
well, I think that's an important point. He has, at best, he has an inchoate potential claim under domestic relations law. If years from now he sought to get recompense for what he put into the property, it's not the same as a recognized right under real property law. There's 2 very important distinctions.
Let me ask you this question. Even if we were to agree with defendant that he's an owner, does he still lose on the direct or supervised part?
No, he does not, because it's, as this court has held in, well, on many occasions, but particularly quoting from Marino versus Continental Towers condo, right, the key question is whether or not he had the right to control or to insist on practices. It's not whether or not he exercised that right. And in fact, a few years later in 2020, Garces versus Windsor Plaza, in that case, this court specifically said that the fact that the agent of the owner in that case did not exercise the authority that they had was irrelevant. What counted as
Well, I think he misunderstood who I meant when I said he. I'm talking about he, the defendant, not he, your client.
Excuse me?
Never mind. I understand your point.
I think your adversary pushes back on this idea that we can look at an agency relationship between spouses. What do you say to that?
Well, there's case law where that has happened. Fisher is one example, and indeed in the Rodriguez versus Mendlovitz case, that was also the case. A spouse, it was held that they were not entitled to the exemption, and they were deemed an agent. And particularly here, where you have a situation where the husband didn't go out and hire a contracting company, okay, who then sent their employee, and then pursuant to his employer's instructions, he's performing a task, he gets injured. Plaintiff was a day laborer that this defendant found at a local gas station. The defendant admits he had no tools, he had no materials, doesn't even speak English. He brought him to Home Depot, get him some materials. He provided the tools, not just the ladders in question, okay? He told him what he wanted done. And they had a history of this going back about 6 or 7 years. He would periodically bring him to the premises and they would do a variety of repairs, including on the subject garage roof. And typically, this defendant, the spouse, would work alongside him. All right, so this is not, again, he clearly was the employer, he hired, he paid, which again is other standards that the court looks to in terms of whether or not there's agency. Are they the person that is directly employing the individual? And here, plaintiff worked for the defendant, Villavicencio, didn't work for anybody else. He worked at his instruction, he used his tools, he used his materials. And under every case that I can find on this issue, he fits neatly within the definition of an agent. And there isn't a single case out there that says that there's some kind of concept whereby a spouse cannot act as an agent for the spouse who is the homeowner. There's no substance to that. And if I could just make one final point, counsel makes, going back to the homeowner's exemption, counsel refers several times to the Bar 2 case, okay, and he says that this should be something that should influence the court, that even though the second department, the fourth department, et cetera, have gone in a different way, you need to look at flexibility on the exemption. Right, but both Bar 2 and the other 3 cases on that topic that he cites, Cannon, Deneen, Romero, varied factual patterns. They all have a common denominator. All right, in each case, the defendant was an undisputed deeded owner of a 1 to 2 family home. Those cases involve scenarios where maybe you have a home on the property and then there's also a garage and there's a question of is there commercial activity there? or in one of the cases, it was the home was being built, so they didn't yet reside there, but it was undisputed that they owned it and they were building their residence. Completely unanalogous to what we have before us here.
Thank you.
Thank you.
Your Honors, page 447 of the record, Mr. Villavicencio says, "We raised our children in this home, we both pay the mortgage." So there is evidence that we both pay the mortgage. So he pays the mortgage.
447?
Yes, page 447 of the record. So there is evidence of that. And there is evidence that for all intents and purposes, for all outside indicia, he was an owner. But because they didn't have the wherewithal or the foresight to put him on the deed, plaintiff demands that he be treated like Tishman. He be treated like Matt Calley. No court has found that. None. If you want to go back to Mr. Fisher, that project that he was working on, he actually developed the architectural designs with the architect. He not only hired and paid the subcontractors and plaintiff, he hired a clerk of the works who oversaw, coordinated, and monitored all the subcontractors. He furnished all equipment and materials, not just for a handyman who came in and patched a roof on a garage on occasion. This was a huge undertaking that Mr. Coughlin, again, who Mrs. Coughlin said was her agent. We don't have that here. And the reason that there's not a lot of cases that show that a husband is the agent of the wife is because most people don't think like that. The fairness that Bartu espouses, the common sense that Salazar against Novilex, where the Court of Appeal said, when you look at 240 cases, you have to use common sense. The courts have to use common sense. When you use common sense and you use fairness, the homeowner's exception does apply to Mr. Villavicencio.
Does it apply as a matter of law, or could it be a question of fact?
I think at the very least, it's a question of fact, but I think it can apply as a matter of law. I think you don't have the control that you have in Fisher in this case. If you wanted to say, well, in that case, plaintiff actually said he acted as the GC. You don't have that here. And I think that goes, again, if you look at plaintiff's arguments with respect to sole proximate cause that we raised as another issue that should be, that when you look at the video and you look at the evidence that there was an available ladder. When you look at that, plaintiff relies on a case called Gallagher against New York Post. And in that case, plaintiff says it's not enough that you actually have an available ladder that would have done the job. Kind of like what this court ruled in Montgomery, the normal and logical response.
So if we held as a matter of law that he was an owner, that has other ramifications, does it not? If we held as a matter of law that the homeowner's exception applied to him, then we're holding that he is an owner.
Yes.
Does that not have other consequences and ramifications in terms of other issues?
With respect to, if the court said, well, then you look at, I think in Mr. Fisher's case, if they had found that he was.
No, I mean in terms of if there's a divorce, in terms of the division of marital property, et cetera, that does have ramifications for your client.
It could have potential ramifications down the road. Again, I think when you look at, then again, that's essentially the bed that they're making.
Which Ms. Brito may not wish to have occur.
Ms. Brito submitted an affidavit in support saying that he was an owner.
Thank you.
Thank you, Your Honors.
Kander v. New York City Department of Housing Preservation. Yes, you may.
May it please the court. My name is Serge Joseph, and I represent Appellate. The underlying case is a succession case relating to a Mitchell-Lama co-op apartment. The apartment initially belonged to my client's son.
So there's some dispute in the record as to when your client resided with her son, during which years, when he in fact moved out.
There is absolutely no dispute as to any of those things. Your Honor, my client provided all the necessary documents proving that she lived in the apartment as her primary residence and showed that she was listed on the relevant income affidavit. The housing company denied the application, and this is important.
So she stated that she submitted a notarized letter from her son stating that he permanently vacated the apartment on a particular date, May 2021, I believe, and that petitioner had lived there since 2015. Did she not submit documentation that showed that perhaps that she was not there during that period of time?
Well, the HPD's decision determined when Greg, her son, moved out, permanently moved out. But, Your Honor, the issue is the housing company denied the application on one basis, on the basis that her son did not provide document to establish the son's primary residence.
Right.
And the housing company, as required by the Mitchell-Lama regulations, HPD's own regulations, said to my client, you have a specific time to appeal and how and what to do in order to appeal and what the appeal should consist of. And the housing company's denial letter said that my client's appeal should contain argument as to the son's primary residence. And my client did so. My client timely appealed pro se without an attorney, appealed to HPD, and provided document as to her son's primary residence.
Were there inconsistencies in the son's vacature date here? Or it's completely consistent throughout the record?
Right, that's what I was referring to, I'm sorry. So in her original application, she said that he vacated the apartment on December 31, 2018. And then in the appeal, Craig stated that he vacated the apartment in early 2016.
In January 2016, after acquiring title to the Bell Harbor home.
Right, so we have a inconsistency between December 31, 2018 and January 2016.
That inconsistency, Your Honor, was explained by my client in her appeal. The son submitted a letter explaining, again, Your Honor, you have to remember that these were not represented, they were not represented by counsel, and explained that although he purchased the home in January of 2016, he would occasionally live and reside with his mother.
But his tax returns from 2015 through 2018 listed the Bell Harbor home.
That's correct. And there's some argument from HPD that his 2015 tax return, which he filed in February of 2016, listed the apartment, the subject apartment, as his residence in his tax return. And we addressed that, Your Honor, in our reply. We noted that he submitted the 2015 tax return in 2016. And by that time, he had already moved out of the subject premises and therefore listed the Bell Harbor home as his residence. And this was, something that I believe the tax authorities encouraged.
So what was your position, or what is your position in terms of the period of the co-residency?
There is no dispute that they cohabitated during the relevant period of time. There is absolutely none. I think, Your Honor, the dispute is the change and what the case was about. And although she submitted sufficient document to establish succession right, HPD said you should have provided more. You didn't provide W-2s.
Also, when did they cohabit together?
What years? They cohabited right immediately after Bell Harbor was affected by Superstorm Sandy in 2012 through 2015. So, and given that she was disabled.
So you're saying that there was a co-residency from 2012 until 2015?
That's correct, Your Honor.
And you submitted documentation as to that?
Absolutely, but Your Honor.
I didn't see 2012 mentioned anywhere in the papers.
No, what I wanted to say, Your Honor, was because she was disabled and was older than 62, she was required only to show cohabitation for 1 year. So the requirement was 2015, and that she provided. So as to what...
Oh, yeah, she's only required to submit documentation, but I mean, if she was there in 2012, then that would have been relevant as well, right? I mean, that would have been the truth.
Your Honor, she provided what,
So she claimed that she lived with her son since 2015. You're stating that she actually lived there from 2012?
Your Honor, the petition alleges that after her home in Belle Harbor was destroyed by Superstorm Sandy in 2012, she moved in with her son. Initially, she thought that the move would have been temporary and that she would refurbish her home, but as that dragged on, she realized that she should permanently reside with her son, and she indicated that to the housing company and to HPD as well. But Your Honor, the regulations though require
You
only
do have time
1
on
year
rebuttal.
cohabitation.
You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. On behalf of the respondent, Dayton Towers Corp., Bruce Sontag, Sontag and Hyman PC. The relevant period of time that we're dealing with here, initially, when Ms. Kander, the appellant, applied for succession, she wrote on her 2021 application, 2018, her son moved out.
Right. She
That
said the son
all-
moved out, that the son was there he moved in 2007, he moved out in 2018, and that she had lived there since 2015.
Correct. What happened was not 2015. What it really was 2016. They did a switch. The son owned the apartment, mom owned Belle Harbor house. In 2016, on the deed to the Belle Harbor house, she listed as her address the Belle Harbor house, selling it to her son and daughter-in-law. They then switched. All the documentation, the son filed his 2015 tax return from the Belle Harbor address.
And she filed her tax returns from 2014 listing the apartment.
Correct. Allegedly, but here's the catch. She filed...
Allegedly, or is that what the tax returns say?
The 2014 tax return was not part of the record, I don't believe.
Yeah, they were.
It was
The New York
submitted
State
on the
tax
appeal.
Yeah.
But what she did...
Yes,
when the
2014 to 2019.
Okay, yeah, you're
And I
correct,
also
you're
have
correct.
income affidavits submitted to HPD
Correct.
from 2015 through 2018.
Correct, and they were both...
Listing-
They listed both of them on the income affidavits, which it's not dispositive whether or not they actually co-resided together. What the hearing officer found, because there were inconsistencies with the deed, and B, with the fact that she submitted a tax return saying she lives in the apartment, okay, and then doesn't supply anything. She's a school teacher, W-2s, she's on this.
How many things need to be submitted?
So HPD has a list. There's
It's
about...
not, you have to do every single thing.
No, it's a preponderance of all the evidence that's submitted, and it's what you take the whole package together, and the hearing officer, based upon the HPD rules and regulations, makes a decision based on what they find. What they found was there was so many...
Well, you don't represent HPD, right?
Correct. No, I represent only the housing company.
Okay. And so your position is?
Our position is that the decision by Judge... the Supreme Court judge upholding the certificate of eviction was valid, rational basis, followed due process, that was not arbitrary and capricious, and that in fact it was sound and that it should stand.
Thank you.
Good afternoon, Your Honors. May it please the Court. Susan Paulson on behalf of the New York City HPD.
So there appear to be inconsistencies, no question, and that was the basis of the decision. But could that be accounted for, the fact that you're dealing with an elderly woman, pro se status, to maybe explain, in fact, that the inconsistencies were not as bad as the hearing officer found?
It might be explainable for that reason. The appeal was submitted by her son, I would note, and he put together the materials. But Your Honor, the problem is that the burden is on the petitioner to submit sufficient credible evidence. And it's not a matter of submitting a certain number of documents or
So what did she
beyond
submit?
the certified tax
What was
returns.
submitted to show the
Yes,
co-residency?
if I may start with what was submitted to the housing company. So in the application to the housing company, in the record on page 145, as you've previously noticed, they said that the vacator date was December 31st, 2018, and they submitted in support of that tax information that listed her address as the apartment from 2015 through 2019, and her son's address as Bell Harbor from 2015 to 2019.
Is there evidence that she was in the apartment before that time?
She said she was in it as of
Is there
2014.
evidence in the record that she was in fact?
I don't, I think there's a 2013 Social Security Administration statement, but may I continue? What was submitted to, if I may, what was submitted to the housing company was this tax information suggesting that her address was there and her son's was at Bell Harbor. Income affidavit saying they were both living there from 2015 to 2019. So accordingly, if the housing company was looking at the period of December 2017 to December 2018, as indicated in our application, the income affidavits and the tax information for her corroborated or established that she lived there at that time. But the information for her son did not, because the Bell Harbor home was listed with his tax information. So the housing company, in its denial letter, said, we need more information to show that your son lived there, because they were looking at that 2017 to 2018 time period. In the appeal that her son submitted on her behalf to HPD, he stated that in fact he had moved out in January of 2016 when he purchased his mother's Bell Harbor home. HPD was now looking at a different time period to determine whether there was co-residency. Both of them had to be living there at that time. So again, the problem—
When you say a different time period, you're talking about up until 2016.
Correct, January 2015 to January 2016 now.
Correct.
The one-year period. So now when they're looking at this, HPD is concerned, A, that they have changed the vacator date. It's concerned that the son's tax returns indicated that he was living in Bell Harbor when he says that he was actually living in the apartment that year, but he filed them the next year, and the fact that the deed of sale said—
What are the inconsistencies in the documents submitted by the son to attempt to establish co-residency between 2015 and 2016?
Well, what HPD was looking at the inconsistencies in the packet as a whole. So we've got the income affidavits. The income affidavits.
I asked you in the beginning, can her pro se status account for maybe some of the inconsistencies, and I think your answer was yes, correct?
I think that her pro se status could account for inconsistency, but—
And in fact, isn't there at least some suggestion that as she moved into the apartment after Superstorm Sandy?
But the inconsistencies were what her son submitted in the appeal is what we're looking at now. I mean, there are inconsistencies throughout.
2015, 2016.
So the inconsistencies are the income affidavits that state that, you know, he was living in the subject apartment through 2019, the tax returns that say he lived in Bell Harbor after 2016, the sale of the house. The problem is with inconsistent information, the burden was on them to provide sufficient credible information. And even in the housing company's denial letter, it pointed them to the regulations that indicate the type of information they should submit. And when there isn't sufficient objective evidence, other objective evidence, given the inconsistencies, again, it's not a magic list and it's not a magic number, but when there are inconsistencies in the record, they want more external corroboration. And here we didn't have that. We didn't have the W-2s. We didn't have from her the Social Security statements for the relevant time period.
And what was the relevant time period? Did you point out what the relevant time period was, 2015 to 2016?
Well, I mean, the housing company pointed out what they thought it was, and then she changed it for HBD. So she was instructed to provide evidence establishing co-residency that both of them lived in the subject apartment for the one-year period. They changed the one-year period. The housing company and HPD were looking at different documents, and they failed to establish with sufficient credible proof that they both lived in the apartment together during the required co-residency period. There was a rational basis for HPD's determination denying succession rates, and Supreme Court properly affirmed it, and this court should as well.
Thank you.
Your Honor, very briefly, the deed is on page 44 of the record. There was a statement by the housing company that the deed listed the Bell Harbor home as my client's property in 2016. That is not the case.
So I think what I'm hearing from HPD is their concern was the inconsistencies of the son's information for the 2015-2016 period, specifically with respect to the income affidavits and tax returns. How do you address that?
The tax return I've already addressed during my initial presentation. The tax return for 2015 was submitted, was done in 2016 after he had moved out of the subject premises.
How about the income affidavit?
I'm not sure what the income affidavit is. I do not believe for 2016 the income affidavit lists the son as living in the apartment. The income affidavits are on page 242 of the. I don't have them readily available.
The standard is whether or not there was a rational basis. Given the fact that we are kind of all over the place in terms of when the son vacated, when there was a co-residency, dates in terms of tax returns, et cetera, why would those inconsistencies not lead to a rational basis to deny when it's unclear exactly what was going on and when it occurred?
I think Justice Singh's question as to whether or not the inconsistencies can be explained by the pro se status of my client below, and whether or not the inconsistencies affected the relevant period of time, I think is germane. The inconsistencies do not. I think the only inconsistency that the city can point to—
Well, first you had him vacating in 2018, and then apparently he vacated in 2016.
He vacated January of 2016.
Right, but she initially stated that he had vacated in 2018.
But the relevant period of time, Your Honor, is 2015, given the one-year co-occupancy, and there is no dispute as to—
But it seems, counsel, though, that you just want people to ignore the 2018 reference in the application. I mean, what do we do with that? It's there. Why is that not the inconsistency upon which they can make their determination?
Except, Your Honor, the HPD found and determined the vacate date of the son, and then went on to say that my client did not provide sufficient document to prove her primary residence during the relevant period of time. HPD acknowledged that my client, in fact, did provide tax returns, Social Security benefit document, but HPD said my client should have provided more. And HPD, before you mentioned the W-2 form, but that could be explained. The tax return themselves show that the income that my client earned during the relevant period of time were minimus. They were $200. So why my client didn't provide a W-2 form can be explained by the fact that she's disabled, and the amount of money that she earned, and those tax returns were de minimis. And they also mentioned some interest income, and therefore my client should have provided 1099.
Well, they said utility. There was no utility bills, voting registration, I think correspondence as well.
Well, Your Honor, some of the documents that HPD mentioned were not provided. We supplied them during the Article 78.
Right, it was after.
We said, here's the driver's license. If we had known you required them, we would have provided to them. And then HPD argued that those documents shouldn't be considered because they are being submitted on appeal, even though below HPD did not require or did not provide my client with sufficient opportunity to provide those documents. So I think, given this record, Your Honor, I think the determination should not be made on the inconsistencies, but should be made on the gotcha and change of the rules in the middle of the game, Your Honor.
Thank you. Edwards v. Arrowgrass Capital.
May it please the court, I'm Jonathan Solds from Greenbrook Charg here on behalf of Arrowgrass, the appellants. Our position is there should be a reversal because the court below erred. It erred when it failed to give any effect to the crystal clear language of the compliance manual and the code of ethics that were incorporated by reference into the subject contract by 5.8. And when it did that, what it identified was an issue which was no issue and was certainly not material.
Justice Maisley found that Edwards was bound by the code of ethics. She did hold that. She just found that there was an issue of fact about whether he'd not complied.
Right.
You want to speak to that?
I do. So there are two violations that we're talking about here. One is with respect to the personal account policy, and the other is with respect to the conflict of interest policy. The pre-clearance requirement of the personal account policy is absolutely clear and non-ambiguous. It provides employees may not purchase or sell any security without compliance pre-approval. It's undisputed that Mr. Edwards went out and got 60% of the membership interest, 21 units of M&A Capital. Whatever he may have said, whatever he may have done to inform Arrowgrass about his involvement with M&A, he absolutely failed to tell anybody that he owned 60%.
And in fact, he testified as such.
He did. That's what his testimony is. That is the material fact. What the court below said was, well, those other things create a factual issue. But it only creates a factual issue to the extent that you totally ignore what the language of the personal account policy is. There are no substitutes. That's what's being said, but the language doesn't admit of that. And under the decided principles, because this was incorporated 5 by 5.8, that was reversible error. The other policy that's involved here, pardon me, is the conflict of interest policy. There is an obligation on every relevant person and their connected persons to report any potential conflicts of interest to compliance. So here you have Mr. Edwards, who owns 60% of M&A Capital. He is a fiduciary because he's a partner to Arrowgrass, and he's charged with the responsibility under the consultancy agreement of soliciting bids for the X-Corp stake that's held by an Arrowgrass fund. Where does the bid come from? M&A. Mr. Edwards is on both sides of the transaction. You can't know there's that conflict, and you can't clear that conflict unless you know that Mr. Edwards owns M&A. And his testimony is, I never told them. Those facts are not in dispute. The crystal clear language of the policies required Mr. Edwards to speak. He had a duty.
Gives an explanation as to why he didn't disclose that. He didn't believe it was necessary. Does that raise an issue of fact?
It does not. It does not. Employees may not purchase or sell any security without compliance pre-approval. Doesn't make any difference what he thought. Those were securities. He had to get them pre-applied and consider what the precedental value of the decision below is. We all know in this city, in this industry, compliance is critical. It protects investors. And pre-clearance is an effective tool used by virtually every industry participant. It protects against front running, it protects against self-interest, it protects against insider trading. Doesn't make any difference what the nature of the vehicle is. You have to tell us you own it. Because if you don't, you can't get pre-clearance. And it's not up to Mr. Edwards to decide. There's a lot more in this case. There's a lot that goes to the fact that Mr. Edwards lied about M&A, called it a family office when he made his reports to Arrowgrass, that he spoliated every document he had that had anything whatsoever to do with M&A. But I don't think it's necessary to get into that. There is no disputed issue of fact. Special purpose vehicle, no exclusion for that, either under the conflict of interest policy or under the personal account dealing policy. I told Arrowgrass that I might stay on the board. Okay, great. You didn't tell Arrowgrass I own a piece of M&A. I think that's really the heart of it. I know it's been a long day for all of us. I'll reserve for the rest, unless you have questions you want me to turn to right now.
Thank you.
Thank you.
Good afternoon, Seth Rafkin for Mr. Edwards and Old Post, the plaintiffs and respondents. Let me start with just one quick statement about factual background here. What Arrowgrass did is refuse, when my client brought in a bid for $73 million to purchase this stake, they had a contractual obligation to negotiate in good faith. They did not do that, and they do not contend that they did that on appeal.
If your client failed to make adequate disclosure?
So let's go to that. My client, they say in their reply that my client never disclosed it and that only in
And he actually testified to that.
No, what he testified is, the specific question was, and this isn't the record, 1558, 1567.
The specific question was, and at or about March 5th of 2019, did you notify Arrowgrass that you owned a 60% interest in M&A Capital? The answer, no.
Correct, and he goes on in that testimony to say, I didn't say specifically 60%. There are multiple times in his deposition where he said there were multiple calls where I disclosed to them that I was involved with M&A. That was repeatedly.
I didn't, and as I said before, I didn't discuss my involvement with M&A Capital in those terms. I discussed it more generally.
Right, and he specifically says in those record sites, he specifically says, I disclosed to them my involvement in M&A. More importantly,
But he also said that he didn't think that a membership interest was required disclosure.
Correct, and let me go to that because Mr. Solds says it is a security. There is nothing in the record that suggests an ownership in this special purpose vehicle is a security. The vehicle is simply
So let me just,
something to
he's hired to, well, as a consultant, they solicit and present bids for sale. And so when he's presenting this, M&A Capital, and there's this conflict of interest provision, there's no conflict if you don't say, well, hey, guess what? I own 60%, a majority share.
That's where it's important what the special vehicle is. He owns, so he has 60% of M&A. M&A is not the one buying it. M&A is a vehicle, that's why it's called a special purpose vehicle, where investors can come in, they can put in the money, they can acquire the asset. Now here's the reason why it is a disputed fact and why even if you were to conclude that, well, it should have been disclosed, it still is not sufficient for summary judgment. This is the testimony of their own general counsel. Question, the fact that Mr. Edwards had an ownership interest in M&A does not operate to bar Arrowgrass from entering into a definitive sales agreement. It may change the process is what you're saying. Answer, it might bar us. We wouldn't know the outcome until we've gone through the process. Question, you would have to do diligence on that and independently determine whether the bid was a fair one. Answer, and whether it had been a fair process. Right. Question, and how would you determine whether it had been a fair process? Answer, we would probably have to hire an outside advisor to review the work that had been done by Mike. That's their own general counsel's testimony. And they did exactly that on another deal That was
So
after
it's
this.
because they didn't do their due diligence to find out that he owned this 60%? I'm not.
No, because what I'm saying is, even if the ownership, they're saying, look, if he has ownership in this special purpose vehicle, which actually owns nothing, then he has, there's no way they can move forward. He's saying the issue of fact is, I did disclose that I'm involved with them, that I'm going to be on the board of this entity because
Well,
the
I
chairman.
thought he said he didn't disclose because he didn't think he had to disclose.
No, that is important. The record cites there 1558, 1567, 1570. Those
He
are to
involved,
his deposition.
he disclosed his involvement on the board. So he half disclosed. He just didn't disclose the rest about the 60%.
He disclosed specifically that he was working with M&A. He told them about M&A. He described it as being involved with M&A, working with M&A. When he sent the bid, it came from M&A. They know that, and they responded to good news.
That the defendants understood that he was an owner?
That working with translated to a membership interest in?
So that's why it's important to, then there's disputed facts about what this special purpose vehicle is. A special purpose vehicle, Mr. Edwards, when this
It was a bidder, right? It was going to bid.
It coordinates.
M&A was going to bid, correct?
Correct.
Okay, and he's charged with getting the best possible bid he can for Aragras. How is that not a conflict of interest?
Because he was bringing in other bids. He brought in bids from.
He misrepresented the valuation.
No,
of the stake.
That is a dispute of fact, Your Honor.
But the other bids that he's bringing in, he doesn't have an interest in those bids. He has an interest in the bid by M&A.
He doesn't have an interest in a bid by M&A.
He doesn't?
M&A is because he was doing that because the board, the chairman and CEO of the company to be invested in wants him to be on the board. So he's saying, okay, one way I can be on the board is if an investor appoints me as their person. He's trying to generate a competitive environment. One thing he does is he forms M&A to facilitate a bid from other investors. He also brings in interests from General Atlantic. I'm forgetting the name of the other two.
I thought he had a membership interest in M&A.
Yes, he did. But what that means is when
membership. So you're stating that a membership interest does not mean that he has that he's going to reap any financial benefit.
correct. Just because he's got a membership interest of M&A, that doesn't mean that he's going to be personally buying any of the stake. The investors come in. There will then be a comprehensive agreement that says, here's the money that's coming in. Here's who's going to get what. Right? And that's what they're all going to be looking at and doing due diligence about. It's not like they sell it and then Edwards gets a cut.
So this special.
He gets nothing.
Whether there's a fee that goes to M&A, that could be some administrative thing, but that would be spelled out in the agreement. The
So
final
he doesn't
agreement.
he's not reaping any benefit.
Correct. Because there's nothing he's holding back from them. There has to be an agreement. If they actually meet their obligation under the agreement to negotiate in good faith, which they never did, and then they have an agreement.
Well, regardless of that, is that not something under his relationship, based upon his relationship with them, that he should at least disclose? By the way, I have a membership interest in M&A?
That's where I think this is a dispute of fact, because what they want to say is, we have no idea what a special purpose vehicle is. These are all sophisticated financial people and investors. They all know what a special purpose vehicle is. If the special purpose vehicle puts together a bid from these investors and it's accepted by Aragras, then there's an agreement. That agreement spells out what one of these investors is getting how much stock, right? So they'll see front and center, right? Okay, does Edwards get any stock? They would see that, and that's why I asked.
But he says that he didn't know that disclosure was required with a SPV, right? So should he not, if he wasn't clear, should he not have still disclosed?
No, that he doesn't say that. He
said that.
No, he
He
told
said
them
that he did not think a membership interest in an SPV required disclosure.
correct in those terms, but he said, I told them, nevertheless, I told them I was involved with it. I told them I'm working on it. He's got them listed in some of the presentation documents, and he's bringing in, and he's telling them they should respond to the bid so that they can then create a competitive environment for others to be bidding on it.
Thank you.
Again, the point is, if there's actually an agreement that spells out who's getting what.
Thank you.
And they said that their own general counsel said, yeah, that's a process we've gone through before. Thank you very much.
So your friend says that because Mr. Edwards was not reaping any financial benefit or would not have reaped any financial benefit, then whatever he disclosed was sufficient.
Let me refer you to the testimony of Mr. Hammerschlag, a partner in M&A, and recall that the bid from M&A, it was a bidder. It was not Mr. Edwards. There was no money in the till. It could not have consummated the transaction, M&A. Nevertheless, they bid $73 million, and there's record evidence that another part of M&A had told a prospective investor, we think it's worth 90. You want to know about a conflict of interest? There it is. Mr. Hammerschlag was asked, so the contemplation was that M&A in some fashion would make a profit on the transaction in some fashion? Answer, if it was consummated and it was successful, then yes. Record, 1486. This was a profit-making enterprise by Mr. Edwards. But it really doesn't matter because, again, come back. The role here is to determine, is there something crystal clear, non-ambiguous that's binding on Mr. Edwards? There is. We've read it to you. He was required to get pre-clearance. He didn't get pre-clearance. It doesn't matter what the nature of the vehicle was. There's some suggestion here this wasn't a security. I'd call your attention to 1099 of the record. It defines security as a certificate of interest or participation in any profit-sharing agreement. Then I'd call your attention to page 1293 of the record. That's from the M&A Capital corporate operating documents. This is the capital account. A capital account shall be maintained for each member. And by the way, if you take a look at 1165 of the record, you'll see the membership interests of Mr. Edwards. Capital account shall be maintained for each member in accordance with the Treasury regulations. 5.2, net profit shall be allocated. The document tells you it was a profit-making enterprise. This was an interest in a profit-making enterprise. It had to be disclosed. And just to come back to the conflict of interest, you can't know how you can clear a conflict of interest if you don't know Mr. Edwards' ownership is involved. He had a duty to speak. Generations of lawyers have learned that about fiduciaries in this state. It doesn't wash. It doesn't wash to say, I told you all these other things that we'll do. What was happening when he told us all those other things? He was making a material omission.
Thank you very much. The last case for argument is Arthur v. ACS. Justice Singh is recused on this matter. Yes, Ms. Arthur, whenever you're ready.
Good evening, Your Honors. Thank you. I'm the grievant appellant, Allison Arthur, of Ava Martinez, my granddaughter. ACS. I called ACS because my granddaughter was being threatened, abused mentally, emotionally by her mother's boyfriend. Ava's mother, my granddaughter's mother, speaks very well. I made sure she graduated high school with college credits, so she speaks well. In the records, all the records it only says what her mother says to them. They didn't do any investigation. They never talked to me. I raised her 5.5 years out of her 6.5 years. I know her from, I've videotaped her life like I videotaped her mother's and my son's. So I have video of everything. I just got this package December 20th. I've been asking for documents for over 2 years. They deny me because I'm pro se. I've uploaded and we did e-file and they would throw it back at me and I would pay and get somebody else to do the paperwork and they do it right. But this to come, this holds so much that wasn't told, that they didn't, they never listened to the child. They always listened to the mother, and the mother bragged about beating her ACS cases and how she's gonna always beat them. And I've seen with my own eyes the negligence of ACS in investigating child deaths. They didn't do a fatality, try and do a fatality review. They were laughing at me in the beginning because they said that I wanted custody. I had a visitation order from 2020 that her mother went along with for months. It was okay until she started to tell me what the boyfriend was doing to her. Then when I called ACS, ACS would go and they would say, she would tell ACS, oh, my mother's obsessed with her. Oh, she didn't do that. Oh, my mother's this, my mother. And then they started laughing at me like something was wrong. I had made 5 copies. I had no idea that it would be 5 of you here, but this is just a small amount of it. ACS did no investigation. Everything says the mother said, the mother said. Then comes to the judge. Whatever Ava's mother wrote into the writ to Judge Ramirez, she would not listen to me. She didn't listen to Ava's lawyer. Ava's lawyer came into court and said she needs her grandmother. The judge said there is no grandparents' rights. She always cut me off. She always muted me and told my daughter, gave her legal advice in court, told her to go and apply for sole custody and do other things and just would never. So I started writing to the Commission of Judicial Conduct about Ramirez, as well as in one of the court sessions, she was slurring her words. So I wrote to the commission a year before the murder of my granddaughter. So the commission meets every 12 weeks. On the third 12 weeks, they finally changed the judge to Judge Paris. And Ava's mother came into that court and that judge said, she started saying, Judge Ramirez said this, and Judge Paris said, this is not Judge Ramirez's courtroom, this is my courtroom, and I am here to reinstate or not reinstate the visitation. The visitation went on for 8 months. If I had a background or anything was wrong with me criminally, I would have never gotten visitation. I cannot have custody. ACS insisted I wanted custody. I had to buy tickets for her because I had to do the order, the visitation order. I kept to it. And so if I had to be out of town, that means I would have to buy her a ticket to come out of town with me. She would have to travel with me because I can't have a child, full custody of a child. I can only do visitation and help you out when you need help, which I did to Ava's mother. Judge Ramirez vacated the visitation order, and 10 months later, my granddaughter was dead. So I found out in this packet that she was having meltdowns in school, and then they would send her to another class in kindergarten. I have on a disc, on a drive, that her education from little. She knew how to spell my name and she knew my phone number. She asked her lawyer. The judge intimidated the first lawyer, Morgan, and then the director of the Children's Law Center was the lawyer with Judge Parrish. On August 31st, we went to court. Judge Parrish said, I get 3 visits. Ava's mother disappeared out of the camera, and she was dead 30 days later.
So, Ms. Arthur, you're going to have additional time on rebuttal. We're going to hear from the other parties.
And can I get this? This is just a little bit of
Sure.
this big old packet.
Yeah, certainly. Your ACS?
Good afternoon, Your Honors, and may it please the court. I'm Alan Racines, representing ACS and the medical examiner.
You can have a seat, Ms. Arthur.
Your Honors, this case is, the underlying facts of this case are clearly tragic, and Ms. Arthur, my heart goes out to you, ma'am. I'm very, very sorry.
Thank you.
We see this case as a strictly procedural case, the way Supreme Court decided it. There's no indication that Ms. Arthur has served a notice of claim. As Your Honors know, it's a contingent precedent to suit. And as Your Honors likewise know, the statutory framework makes it clear that you can't even serve a late notice of claim after the limitations period has run, and it has here. The child died more than 2 years ago. And that was something that the court, as it noted in its decision on appeal, the court had already informed Ms. Arthur Brown in a previous decision of the necessity of doing. The other, even more fundamental basis that justifies the court's decision here, Your Honors, is simply that Ms. Arthur has not shown that she is, in fact, the personal representative of the decedent's estate. By law, she needs to get a letter from the surrogate's court designating her as having that status, and she has not produced that. So, in effect, she's trying to assert someone else's claim, and that's a very basic reason that the case that she's brought can't proceed. So, Your Honors, those were the two arguments we asserted in our brief. I'm happy to answer any questions you may have, but with that, otherwise, we ask this court affirm. Thank you.
1 second. Go ahead. You represent?
The state respondents. As the city has addressed the service and standing issues, I will just very briefly address the 2 additional independent grounds to affirm the dismissal here for the state respondents. Specifically, it's well settled that damages actions against state parties belong exclusively in the Court of Claims. Supreme Court, therefore, had no subject matter jurisdiction to even entertain this case against the state respondents. Second, judicial immunity bars the suit against the state respondents because their actions fall squarely within that doctrine. The state judge in family court was conducting proceedings and issuing orders in her official capacity as a judge. Similarly, the Commission on Judicial Conduct is immune from suit for its role in reviewing and adjudicating complaints against state judges subject to review by the New York Court of Appeals. And the Commission has no authority to assign judges to cases, much less so on the specific Bronx Family Court. For these reasons and those stated in our brief, we respectfully request that the court affirm the dismissal of the state respondents.
Thank you. So, Ms. Arthur, you have you have time on rebuttal. I just wanted to explain a couple of things to you. We are only dealing with the procedural issues of this case. And as was stated by counsel for the city as well as counsel for the state, there are certain procedures which we have to address. One is service, whether or not the individuals were properly served. The other, and perhaps more fundamental, is the fact that the law in this state is that in order for you to prosecute a case for your granddaughter, who, my heart and I think my colleagues' hearts go out to you in terms of the death of Ava, But the law states that in order for you to prosecute on her behalf, you have to obtain letters from surrogate's court appointing you as the trustee, et cetera, of her estate so that the case can be prosecuted. You cannot do so in your individual capacity. And again, there are certain procedures in terms of filing the service, as well as was stated in terms of when you sue the city, when you sue the state, who is immune from suit, et cetera. But more fundamentally, you as an individual cannot pursue or prosecute on behalf of Ava. You have to obtain the permission by virtue of letters from surrogate's court in order to do so.
Thank you, Your Honor. Thank you so much. And I did want to address the time. I sent in the service. Actually, they were giving me the runaround, like 27 Madison, take it here. I've been all through the building. We went all over. But there was 2 service in service. We went to Corporation Council, where you go through the little back, and they got the little office there and everything. My sister told me. So I put those 2 services in there because the judge said that I didn't serve in time, and I knew a year and 90 days. I already know that's the time you have. Now with surrogate's court, I didn't know that I could go, and because I practically raised her. She was with her mother only for the 10
No,
months.
I understand, and you
Yeah,
know,
10 months of the
right, and individuals, may not know that, but in order to prosecute on her behalf, because you're prosecuting in part on her behalf, you do have to get the permission, I'll use the term permission, from surrogate's court in order to do so. So that's like a fundamental issue. And then service is also an issue in terms of, I said, the
But
city as well as the state.
Did you see the service? I had sent the services were perfect because they were served actually twice in person. But the judge, Judge Kim, I forgot her last name.
Yeah,
Judge Kim.
Adair. Wilson, excuse me.
Judge Kim Wilson. She did. I gave them to her that they were served. I don't know why she would say they weren't served, because they were served in person by certified mail. She thought they were only served by certified mail.
Right. Well, she did render a decision, but I just wanted to be clear with you that we cannot address the underlying issues as to the death of your granddaughter. We can only address the issues as to that were brought up on appeal in terms of the dismissal of the complaint because of lack of service, personal jurisdiction, and also the issue of standing, meaning you're representing your granddaughter. Those are the only issues that we can address. We cannot address any issues as to any negligence on the part of ACS.
Yes. So so Ms. Kim, Judge Kim did not have jurisdiction, because she did say something like that. She doesn't.
Well, the state is arguing that she did not have jurisdiction, at least as to the state defendants, because those cases would have to go to the Court of Claims, and or the service was improper in terms of personal service.
Okay.
Okay.
But do you see them as improper because they were all filled out?
Well, again, this is a determination that we would have to make after looking at all of the papers and the briefs and the arguments, et cetera. We will make that determination. But I just wanted you to know that we cannot look at the substantive issues in terms of any negligence on the part of ACS, et cetera. Okay, we only deal with the procedure.
Now,
okay?
So because I have all of the, like more doctors, I have everything.
Yeah, you know what, you may.
Do I take that to surrogates?
You may want to retain an attorney, or at least get some type of legal advisement. And you can certainly go to surrogates court, and they have a pro se clerk at surrogates court, and you may be able to speak with them further.
And is that the only thing it was, surrogates court, and the
Well, as I said, you may want to retain counsel. You may want to seek some type of legal advice.
Yes.
Thank you. Thank you all.
All right. Thank you.